Okay, we're back. What's up, everybody? Hey, everybody. What's up, Doug? Nice to see you in here. Laserific. What's the matter? You, Copsar 5150. Born to be Free is the best name in here so far. Ralph, I see you, my guy. Austin, what's up, my brother? Too much. Too much imps. Too much imps. Turn it around for a W. We getting wins in them imps. Know we coming down. Y'all, you better watch out for him. Getting to the knowledge, call me him. I'm the man, no why. Come around, yeah, you call me Cam. Yeah, I'm gon' stand by my man, yeah, Luis. Ichiobara coming down, we gon' win. They talking about he did something foul, but only thing I'm seeing how they acting out loud, and boy, we get to speaking. Oh man, they stopped the song. Well, we're waiting on this court. We're waiting on this court. I don't know. We're waiting on them. Nothing's popping off yet. Got two different screens. This screen is supposed to be alright. It's alright. We'll fix it. We'll figure out how to do it in a minute. But yeah, Luis is about to go in with a here, let me pull it up real quick. Show y'all what the boy done filed. Bear with me now. Bear with me. Yes, this is live court. Okay. Switch it. Okay. Well, this needs to go on the bottom for right now. Uh-oh. Okay. Y'all can see what's going on. Good. Let's turn this music down. It's banging. Banging in my ears right now. If I turn it down too much, y'all can't hear any, huh? Okay. Well, I guess that's good. Right? Yeah, man. All right. So we're coming up. This is what he filed. He also filed a memorandum. Yeah, this is just the notice and demand. I have to turn this down in my headphones. It's too loud for me. Can't concentrate. Okay, that's better. So Luis filed this notice and demand to dismiss under CRR 8.3b for unconstitutional statute as applied. It comes now the defendant Luis Armando Ochoa Ibarra, appearing in proper persona, and respectfully moves this court to dismiss the charges and the court's inherent authority on the grounds that the presumption and or application of certain statutory provisions to defendants' circumstances is unconstitutional. Such application violates both the Washington Constitution and the United States Constitution 4th and 14th, specifically the state's attempt to prosecute defendant for forgery, obstruction, or administrative vehicle infractions absent any proof that defendant used the roads or plate in a for profit or gain, probable cause, or complaining party constitutes an unlawful as applied extension of the underlying statutes. Factual brief background. Right, we go through his whole story. Officers of the Stevens County's Department demanded identification and threatened arrest for purported vehicle code infractions, including failure to register title or operating with a fictitious license plate despite no articulable suspicion of a felony or harm done to any person, and was never used for profit or gain. Officers subsequently escalated the administrative and victimless allegations to felony level forgery, lacking any demonstration of intent to defraud or proof of profit or gain. 4. The state, via prosecutorial action, threatens further enforcement, thereby subjecting the defendant to potential incarceration and property confiscation without valid probable cause of a showing of harm or using the public highways in any way for profit or gain. Clearly. Now, the last motion that we went through was the aspect of the statutory framework, right? So, anyways, and the court's inherent dismissal authority. Washington Criminal Rule, CRR 8.3b, empowers the court to dismiss a criminal proceeding in furtherance of justice. Again, in furtherance of justice. When the governmental, I need to take my mic down. I'm blowing it out. Okay, yeah, that's loud enough. Okay, cool. When government misconduct results in prejudice to the defendant's right to a fair trial, which they've clearly done. Additionally, the court retains inherent authority to dismiss a case if the presumption and or application of a statute contravenes constitutional principles under the particular facts at issue. B. As applied constitutional challenges. Number 1. As applied standard. An as-applied challenge concedes that the statute may be valid in the abstract, but is unconstitutional in its application to the defendant's specific circumstances. 2. Relevant constitutional provisions. Article 1, Section 7 of the Washington Constitution guarantees stronger privacy protections than the Fourth Amendment, prohibiting unwarranted intrusion without sufficient cause. Thank you. What was the cause? Where's the nature and cause? Fourth Amendment. U.S. Constitution bars unreasonable searches and seizures. No probable cause or legally cognizable suspicion existed for a custodial seizure in a private property context. 14th of the U.S. Constitution ensures due process of law. The application of an ambiguous and overbroad vehicle/forgery statute in this context violates fair notice and rationale application. And you want to know why that is? Because they don't even got case law that says that the license plate is, or should I say, his own private property and placard can be applicable. All they got is trip permits. They trying to use trip permit, which is an official governmental document, a written instrument by definition, as being applied to his private property. That don't apply. There ain't no official seal on there. That ain't no official document. Why are you trying to go outside of the statute in its application? That's why we invoke the rule of lenity, and they done violated that, so we're going to come back for that. Don't worry about it. It's all good. Again, 3, notice requirement, where an as-applied challenge implicates the validity of a state statute. Defendant has provided and will continue to provide any necessary notice to the Washington Attorney General and other required parties to comply with RCW 7.24.110 and applicable local court rules. Argument. 1. No harm, no complainant. The impetus for the forgery or title registration charge is purely administrative. The state cannot lawfully criminalize conduct on private property absent a complaining victim or a recognized corpus delicti. What you mean here, bruh? The absence of any tangible harm or injury renders the imposition of criminal penalties disproportionate and unconstitutional. 2. Vehicle code as a pretext. The state's statutory scheme, although broadly intended to regulate commercial and public vehicular operation, is inapplicable to a non-commercial statutory scenario on private property. Enforcing such statutes in this context not only violates the defendant's privacy under Article 1, Section 7, but also constitutes an impermissible expansion of regulatory authority, especially here in Washington when we got quotes such as this. Here, let me show you what we got. We got Supreme Court justices, man, over here talking about this, man, in big, bold letters. Like, I don't know what they over here sitting and playing with us for. You know what I'm saying? Like we just ignorant or something out here. Like, we just dumb. Ignorance of the law is no excuse, and we ain't got none of that over here. So they better get it corrected, because we ain't playing with them, bro. Y'all will be held liable for the violations, and that's a fact. Now, I'm going to zoom this in just so everybody can see, and anybody else who's spying and watching and who's hating and against everything that we're doing. I'm going to actually have to try and gain some RAM here. It looks like my RAM's running low. It's all right, though. see if we can get this zoomed in a little bit. We'll fit this to the page. All right. Now, listen to these words. These words came from a Supreme Court justice here in Washington, the same state that Louise is going through things right now. Complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet under an act like this, arbitrarily administered, the highways may be completely monopolized if through lack of interest.
Did you want to take up with Mr. Kendall?
Oh, you're just gonna ignore it? You're just gonna interrupt me like that, huh? No, so we're muting you. We're gonna finish this first. Like I said, complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads. We forgot the days of the robber barons and toll roads. Okay? We forgot that. Complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads. The only thing is the robber baron position has changed and translated over to the state, to these agencies and toll roads, and yet under an act like this arbitrarily administered, the highways may be completely monopolized if through lack of interest, meaning me and you standing up, the people submit, meaning me and you not standing up, then they may look to see the most sacred of their liberties taking from them one by more or less rapid encroachment. Unquote. The words of Justice Tolman ring most prophetically in the ears of the American citizens throughout the country today, as the use of the public roads has been monopolized by the very entity which has been empowered to stand guard over our freedoms, that of state government. Let's do it again. The most sacred of liberties which Justice Tolman speaks of was personal liberty, which has been placed in conflict with the plaintiff, me, Luis, everybody. The definition of personal liberty is, quote, personal liberty, or the right to enjoyment of life, liberty, is one of the fundamental or natural rights which has been protected in its inclusion as a guarantee in the various constitutions, which is not derived from or even dependent on the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. Unquote. 16 CJS Constitutional Law, Section 202, page 987. We'll keep going. This concept is further amplified by definition of personal liberty. Quote, personal liberty largely consists of the right of locomotion, to go where one pleases, only so far as restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted, okay, or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal circumstances, travel at his inclination along the public highways or in public places, in roads, and while conducting himself in an orderly and decent manner, neither interfering nor disrupting another's rights, he will always be protected, not only in his person, but also in his safe conduct. Like, you're not going to refute anything that has already been dictated and stated and said. Move around. Okay? We ain't playing that. So, vehicle code as a pretext. The state's statutory scheme. It's a scheme. Forgery charge lacks constitutional or statutory basis as applied. Okay? Uh-oh. Okay, everything's fine. Yep, we good. Okay. Intent to defraud element unmet. So RCW 9A.60.020 requires a specific intent to defraud or injure. The mere possession or creation of a private plate designed solely for the purpose of protecting personal information and not being used for profit or gain does not evidence any such intent, as held in State versus Scobie. The absence of intent nullifies a forgery charge. 2. No legitimate state interest in criminalizing harmless self-identification. The statutory language of forgery is meant to apply only to state-issued instruments. State-issued instruments. What don't you understand about that, prosecutor? How could you be so far away from understanding the truth of the aspect of what you were supposed to apply in relation to the statute? How can you be so far away from the interpretation of what the legislation put in its initiation when they created it? How can you not go back all the way when invoking the whole Rule Act in and of itself for you to comprehend and know that it was only in relation to actual taking documents, replicating them in some fashion to try and fabricate a forgery, to try and counterfeit? There's no counterfeit involved whatsoever. Okay? Let's see here. As privately fashioned plate does not mimic any official state credential, does not fall within the ambit of forgery. The legislative intent clearly delineates that only official documents bearing state authority are subject to such scrutiny. What don't you understand? Why are you being like out of bounds with what your job entails from we the people? Stevens County, you got a bad prosecutor. You need to get it in line here, guys. You need to get it in line, okay? Dismissal is warranted for governmental misconduct and prejudice. Number 1, the arbitrary action, the escalation of administrative infractions to felony level charges, is arbitrary and without factual foundation. Such prosecutorial overreach is manifestly prejudicial and infringes on the defendant's right to a fair trial as required. The material prejudice. The imposition of baseless felony charges subjects the defendant to potential incarceration, significant reputational harm, and undue stress, all of which constitute material prejudice that cannot be remedied by a later evidentiary hearing. The conclusion and prayer for relief. For the foregoing reasons, defendant respectfully requests that this court, issuing an order dismissing all charges against the defendant under CRR 8.3b and the court's inherent authority, finding that the relevant statutory provisions as applied to the defendant's conduct violate the Washington Constitution and the U.S. Constitution. Alternatively, declare that any attempt to prosecute the defendant for forgery or failure to register title under these circumstances is unconstitutional as applied. Grant any further relief deemed appropriate in the interest of justice and to preserve the defendant's constitutional rights. Okay? So we're not playing with these things, y'all. We're not playing. That's just the actual notice and demand. That's not including. Uh-oh, we got a super chat? Super sticker, super chat? Let me check it out. Autumn Cole with the 20. Thank you, dear. Y'all, everybody in the chat say thank you, Autumn. Please, y'all show some love and say thank you, Autumn. Autumn's been around for a long time. Much blessings, much love to you, my dear. Let me see what we got going on here. We're gonna search up Louise. I'm lagging a little bit. I'm gonna need to hit for a quick refresh on the memory, man. What's cool is I rearranged my desk. I got the iPad up, so we're kind of good on making sure that the chat's flowing now with the iPad. Everything is yeah, okay, so I can see everything with the iPad. This is really pleasant now. Got all messages. Thanks to Pig's daughter for hooking up everything with the links. Shoot me an email later. I want to speak with you a little bit further. A couple things. I just want to let y'all know that we really appreciate y'all being here for Luis. It means the world to us, y'all. It really does. So this is his memorandum. This memorandum is 11 pages. He worked very heavily on this. I know because he asked me a lot of questions. But this is his memorandum in support of the notice to dismiss. And it's thorough. It's very thorough. He went into the lack of injury in fact. As recognized by the courts, a legitimate criminal prosecution demands evidence of actual harm, injury, and or a complaining witness. In this context, injury in fact. And what you'll notice is there's footnotes and everything here, right, to go in relation to more of the deeper points that he's bringing up. And in that, they're all right here, explaining that corpus delicti typically requires proof of an injured or loss caused by another's criminal act. And so everything is backed up very heavily in relation to all the documents that we're doing. So when it comes down to it, y'all, like us being pro se is a lot more, like I have to put it to you like this. Nobody is ever going to work harder in your case than you. There's never going to be an attorney that represents you harder. There's never going to be anybody else that represents your case better than you because you know the facts of the matter of the case, guys, right? So that's the biggest thing that we all need to focus on is that you're going to know the facts of the case the most. There's nobody else that's going to know the most, and there's nobody that's going to defend harder than yourself. And so with that, you can clearly see how detailed we're really going in this and how important it is that we just stand on it and call out the issues. And now that we know the issues, we bringing forth, when with all of this comes a lot of dedication. A lot of dedication to figuring out the rules, to figuring out the procedures, to figuring out what you need to know in this situation and moving forward. It's not just about this situation. It's for you. It's for your family. It's for your loved ones, because we can see the encroachment is consistently getting worse and worse and worse and worse and worse. And hopefully, I don't put myself too much into the politics aspect, even though there is a lot of traction and movement right now in relation to freedom being brought forth again. We still need to be prepared. There's oh my gosh, Wasamata, you throwing another super chat, y'all. Thank you for the love, y'all. I appreciate y'all. Wasamata you says, an unacceptable expansion application of commercial vehicle code not intended to interfere with Americans' personal business, which is a crime to interrupt. Thank you, brother, for the donation, and thank you for that message. It's very true. Very true. So let me see here what we got going on. Luis is still chilling. So let's just go over a couple more things then in his memorandum, right? So a suspicion that the vehicle plate was not officially. So no occupant at Spoko Fuel alleged wrongdoing by the defendant. No store manager reporting a trespass or theft. No bystander called for assistance. Instead, the impetus was purely administrative, a suspicion that the vehicle plate was not officially issued. Wow. I need permission from the state. Mommy and Poppy, please put this sticker on the back, this barcode that gives me authorization to travel on my own roads. Please. I need your permission. Bro, we live in a self-governing republic, okay? Like, for people who don't know when they make fun of sovereign citizens, let me just clarify something real quick for y'all, okay? Joint resolution, that's what it's bookmarked under. And when we come into this joint resolution that was signed back in 1940, in relation to I Am an American Day, we'll look in this preamble right here, and what we can notice is that it says, whereas some 2 million, come on, computer, 2 million young men and women in the United States each year reach the age of 21 years. And whereas it is desirable that the sovereign citizens, good old sovereign citizens of our nation, be prepared for the responsibilities and impressed with the significance of their status now in our self-governing republic. That's right. We live in a self-governing republic, Yes, sir, we do. That means you get to self-govern, and you get to self-govern, and you get to self-govern, and until you mess up and harm another person, you can do whatever the heck you want to do. Why? Because you're a creation of the Creator, and we live on this holy land of America, also known as Huehuetlapalan. And that's how it works. I know this is about Louis, but I will go ahead and say to all of y'all right now, if you didn't know, looks like me and Brandon Joe Williams are getting together to do a conference in Austin, Texas. Looks like we are. If y'all are wanting to come through for a 3-day event, hey man, here it is right here, y'all. Here it is right here. Well, if my computer would act right, I guess it's wanting to go slow today. Let's do a view your event. And apparently I gave y'all the wrong link too. Oh, I'm lagging. Oh gosh. Oh no. Oh no. My whole computer is lagging. I'm sorry. Y'all give me a moment. Yikes, Papa. Okay. Copy. And we'll take this link out. If I can do it properly, remove, and then boom. Let's see if I paste it. And here's a link, a pig's daughter, for that as well, if you want to grab that link. So yes, this is the Eventbrite. It's going to be a 3-day event on the weekend of April the 25th through the 27th. Y'all know me. Y'all know I go overboard with everything that I do. So you better expect you to get your value out of this $300. Okay. You better really expect to get way more out of me than you could ever expect, because I don't play around. I'm not hyping myself up. Y'all already know. You see it. I go overboard. And if you're meeting me in person, you know I'm not just coming to talk. I'm coming with documents, not PDFs. And they're going to be placed in your hand. You understand what I'm saying? Every member is also going to get a free book. Okay? See this book right here? Self-Governed, bruh? You're going to get a free copy of this book as well if you attend the show. Austin, Texas. Come on out. We'll be there. And we'll talk about it at a later point. This is about Louis. But we haven't gotten to him yet, so we're kind of just waiting. Okay, we're waiting to see what's going down. So what we'll do is we'll get back into his memorandum. Just wanted to throw that out there for everybody. You know what? One more thing, too. Y'all know I've got 2 different books, but I'm just going to let you know the easiest way to kind of book anything with me, as far as if you're wanting to schedule a quick call, or if you're wanting us as far as to get involved with you on anything that you need to get taken care of, or just get some extra advice. Check it. You know, we got over here. You can go to bio.site/CJW. Bio.site/CJW. It's the easiest link ever, y'all. Of course, you can do a 90-minute consultation. We got the 15-minute consultation. We got pre-order right now. It's getting printed. They should be done tomorrow or Thursday as far as all the books. You can come over here and pre-order that as well if you want to. That's available. Everything's running so slow, I guess, right now, just due to the fact that I'm streaming. So we got Self-Governing, bro. That's the brand new book. That's amazing. We got PDFs available for Rebut That Shit. We've got my first book, which is The Last Tread, that is going into detail of all of my experience on the right to travel and a lot of case law. And then, of course, beginner right to travel course, advanced right to travel course. If you're having really, really, really big serious issues and you need to stop the court immediately, we do have an injunction process with a temporary restraining order. We have the traffic law reform, where we are moving forward in getting our traffic law reformed. There's a petition you can sign there. You can come into the Operation Wise Dome Discord, where it is insane in relation to all the work that we are doing on the back end. And if you want to just see the back end as how that goes, let me show you. I think we have over 40 different people that we're individually helping right now in the Discord. I think Doug can attest to this. I think JC Miller can attest to this. There's so many people in the chat right now that can attest to the phenomenal work that we do in the Discord. And I think it's just phenomenal because, again, Wise Dome is in correlation to Mastermind. And a mastermind, if you don't know, is not one individual that knows it all, but actually a collective group of individuals that come together to make one mind. And that's the beauty. That's what's so beautiful about what we are doing. What we have done and what we have created is a collective group of individuals that are coming together to empower each other all in every aspect. And to see how people come in scared, fearful, not knowing what to do with the court, and then going to court, firing their attorneys, standing up on that, and getting cases dismissed is the most beautiful thing. I never would imagine that this is what we do, but we've done it. And everybody in the chat will attest to that, I'm sure. Now, what I want to show y'all real quick before we hopefully get into Luis's situation, of course, this is the Discord. It's popping off, as always. It's slowed down because everybody's in the live right now. But over here on this side, you'll see casework, and we start right here on casework. Let's count these out. So we got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41 different aspects of people that we are individually helping in here, developing all kinds of things together with the people, with the clan, with the Operation Wise Dome group. Everyone's in here doing things. You see their statuses, their updates, what they're filing, what they're about to file. We get in here and do all kinds of developments, y'all. This is what we do in Operation Wise Dome, and it's so empowering to see what we're doing. Okay, and I just want to let y'all know about what goes on in the back end. You may see the YouTube and you're like, oh, cool, great YouTube, but do you see the real work that's going on in the back end? It's a lot, and this is where we empower ourselves. Also, last thing, we have 2 meetings every week, okay? Every week we have 2 meetings. The meetings are Wednesday night, 6 p.m. Pacific Standard Time, okay? 6 p.m. Pacific Standard Time, Operation Wise Dome, and Saturday mornings, 9 a.m. Pacific Standard Time. This is where you can come in, speak with us. We individually work with you. We go deep, deep, deep. We're about to start up a series going into jurisdictionary. You don't want to miss it. It starts this Wednesday, okay? You can go to the website and, again, bio.site/CJW. You can find out how to get into Operation Wise Dome, okay? That's a lot. I know we got a lot going on, but hey, I can't do anything but try to provide the best value to you guys. I don't know what else to do. With that being said, I do want to take a moment to take a quick smoke break, because man, I just ran my head off here, and I think I'm entitled to a quick smoke break. I want to see what this music aspect is selected on its filters. Let's see, properties, desktop audio capture. I'd rather do a certain application if you don't mind. So let's do QuickTime. Yes. We'll do OK for the music. And yeah, hopefully just music's playing right now. No? No? Okay, it is.
And 24-1-158-33. Mr. Green, are you able to unmute from the jail? That we can hear you. Can you hear us?
Yep.
Okay, Mr. Reed, have you seen Mr. Green's client complaint at this point?
I have, Your Honor.
And based on your assessment of the attorney-client relationship, do you believe that the relationship is irretrievably broken at this point in time?
I do not, Your Honor.
Okay, and then my understanding is that you're still currently working on Mr. Green's case?
I am, Your Honor. And Your Honor, I think it's probably helpful here to lay a bit of a record. I won't take too much of the court's time. Mr. Green has engaged or is engaging in a systematic process of filing these complaints, calling my office, asking me for particular resolutions that he knows he's not eligible for. He has contacted somebody from the Stevens County Jail, Ms. Wysocki, in an effort to get into a treatment alternative that he is not eligible for. At the time when he does make those comments or claims to whomever it is, whether it's Ms. Wysocki or other individuals, he expresses his desire to go to treatment. I have explained to him over and over and over and over again that he is not eligible statutorily for a treatment. So when he does not get the answer that he wants from whether it's the jail or his family has reached out to a treatment facility in Idaho, I spent about 45 minutes on the phone with a woman from Idaho in the program over there.
Okay, let's see how everything's working here. Check, check, 1, 2. Check, check, 1, 2. Okay. So it looks like we're currently still waiting. Let's chit chat for a little bit if y'all want to. Okay. Lynn, thanks for being in here, Lynn. Crypto Prepper, I see you back in here. Can one of the mods post that link for Mastermind? It's on CJW or bio.site, Crypto Prepper. bio.site/CJW. You'll see the Operation Wise Dome link if I'm not mistaken. Let me check real quick. So under bio.site, if you scroll down, you will see Operation Wise Dome weekly community meetings. That's where you want to be at, brother. That's the link, my guy. Okay, make sure we're live. Is everything good? All right. Again, every meeting is on Wednesday night at 6 p.m. Pacific Standard Time, as well as Saturday mornings, 9 a.m. Pacific Standard Time, 11 a.m. Central Standard Time. We do 2 a week, not just one, y'all. So you're getting a lot of value out of what we're doing. Again, every member that's in the chat right now, why don't y'all go ahead and tell them how much you're enjoying Operation Wise Dome since its creation? I mean, I don't know what else to say, man. We really doing this. It's really something amazing, and it's beautiful. I love every single one of these people, and it's because I am you and we are us, and we are all part of the great I am, man. It's just a recognition of knowing. It's been that way from the very beginning. It's not very hard. They've separated us by color and creed and culture as though that is relevant. There is no relevance in this. All of this court proceeding that Louis is going through right now is not relevant. When we see wrongdoings happening, we need to humble ourselves and say, my bad. I am sorry. Why can't we get back to that? Why is it so hard? I don't understand. Oh, because the rules say, nigga, those are colorable law, bro. That is not real. That is corporate statute code policy. It don't even apply to me. Nigga, I am the top dog. Which I don't understand about that. You over here attacking me and making me go through all this, and I'm the top person. You got people over here profiting. We, the state, you got people over here profiting. These prosecutors right here on the screen right now. You got these prosecutors on the screen right now profiting off of the torture and pain of Luis when Luis is a God-fearing man that literally is a community member, like helps people, preaches to people, literally was preaching to the deputies. Me and Louis, check it, ain't this crazy? Me and Louis go to look up Jason Lee, one of the deputies. That actually was pretty fair. He said his uncle was a constitutionalist too, which there's nothing wrong with being a constitutionalist. Like everybody should be a constitutionalist. Why are y'all making that seem bad? Oh my gosh. Let me mute the music. My bad. It's bad out here, bro. They be tripping. Being a constitutionalist, like everybody should be a constitutionalist. Why are y'all making that seem bad? Oh my gosh. Let me mute the music. My bad. Well, I'll let y'all have the music a little bit, but I just didn't know how loud it was. I had to check on everything real quick. My bad. But they still in the court. They ain't talking about nothing. A whole bunch of nonsense right now. So let's check out the chat again. Machining services. So much information and helpful people. Thanks to everybody. No, thank you. Thank you for being here. Thank you for being a part of Operation Wisdom. Thank you for being a part of the great I Am. Thank you for caring for others. Thank you for wishing and hoping and desiring and acting to bring forth the unification of our people again. Thank you for being compassionate. Thank you for standing with honors. Thank you for always acting with the highest of morality. Thank you for bridging the gap. Thank you for all that you are. Like, this is, like, I'm gonna make an announcement, bro. Like, I don't know if y'all know this. We got blessed. This channel, this community, this people just got blessed. And we just went super viral. We got one video, a short, that is almost at, it's over 3 million views in less than 10 days, y'all. 3 million and less. Our message is spreading. Okay, we're coming up on 30,000 subscribers like nothing. Why is that? Because it's time. Everybody wants to unify. Everybody wants to correct the wrongs that have been done. You know, in history, we see it in relation to a lot of our people figuring out what's going on with America. Just how bad history's been changed on us as far as knowing the truth of who are the mound builders and who are the Indians of this nation, and just that whole community and history in and of itself, and just how much we've been duped and lied to in relation to the people that were found. Yo, man, there's just so much that's going on, and it's an enlightenment, and it's the age of Aquarius. We know for sure. We know this for sure. Like, you can't stop that. But it's not a thing of division either. It's not going into the aspect of us against them. It's going into the aspect of unification again, that recognizing that, again, color and creed don't matter, bruh. Like, what you mean? None of that matters. None of that matters. All that matters is knowledge. All I've asked for all this time and everything that I do is let knowledge empower our people for ages to come. Over here on this side, it's I am you and we are us, and we are all part of the great I am. But in that, man, we got to start helping each other. We look at Erica's situation and what's going on with her. She ain't ever been in trouble ever in her life, bro. She ain't ever been in trouble in all of her life. Now you got cops all of a sudden ripping open her door because she rolling up her window because she fearful of how this dude yelling at her because he over here strung up on a Red Bull jive, getting all hyped up. Oh, you're gonna get out of the car. Like, why, bro? What I do wrong, bro? Like, back up, dude. Like, calm down. Like, what your issue is here? Why is that? You know, I've never been violated, bro, by any other person than a police officer. Do you understand that, man? I am so cool with everybody, bro. I don't have no problems with nobody, bro. Unless, like, you do something foul and I call you out. You know what I'm talking about? Like, that just happens, though. You can't stop that. Like, I come from Dallas, so we not just gonna be like, and ignore it. Like, we gonna tell you like it is. What? Huh? No, you're not gonna talk to me like that. I could show prime examples, but it's not to be rude. It's just like, hey, calm down now. What you got going on? I'm trying to get you out of that mental state to get you back to positiveness. You know, like it's like somebody drive crazy on the roads or something, right? Almost wreck into me or something. I'm not gonna road rage pull up to you, you mother, you know, and stick it. I'm not gonna do all that. I'm gonna wait till we get to a spot, roll down my window and say, hey man, you got to be safe out here, bro. Like, I'm gonna tell you right now, I lost a leg, nigga, and I died, bro. They had to bring me back to life from a car wreck. Yo, that rushing you doing it ain't worth it, man. Like, be a little safe, bro. You dig? Like, for real, man. People got children out here, dog. You see the approach? It's totally different because it's a control of emotions. Once you get a control of emotions, impaired or in conjunction with knowledge, perfect plug, knowledge, okay? Knowing and knowledge will get you into the aspect of never being in fear again. Because all you're going to do is you're going to stand on your constitutional rights and you ain't going to waive them. Thereby, when they ask you to get out of the car, thereby when they request, I'm going to need you to get out. Listen, I don't need to get out of the car. And you can ask all you want, but I'm not going to. Okay? You're not going to violate my constitutional rights today. Are you? Are you going to violate my constitutional rights today? You're not going to violate my constitutional rights today. And people be in the chat going off on me being like, they're not your constitutional rights. I get it, bro. Can I speak blandly to the public who doesn't know exactly how all this goes right now, to then they can come in and learn everything? No, you don't have constitutional rights. You have what's called creator endowed rights, if we're getting into it. And those rights go well beyond the constitutional limitations in which the government that we have created that is under us is bound to uphold. Go read the Federalist Papers, Declaration of Independence, the Bill of Rights. Then go read some canons, then go read some maxims, then go read natural law, then go read common law, and understand that your rights go well beyond the Constitution, bro. That's just a boundary that these people are set by because we create them. We didn't want to have to do all the work when we initiated this, man. We were like, oh man, well, I'm not going to be doing all the keep up in my local area. We got to hire somebody. And guess what? All the people came together in their local regions and areas and said, guess what? Y'all can take this much amount of money that I'm willing to pay for to make sure that everything runs in a perfect order. That way we don't have to do it ourselves. Yes, they're still our servants. Do we need to be rude? Do we need to be mean? Do we need to be hostile? Does it need to be us against them and those jackboot thugs? No, not always. Sometimes you can be rational in your approach. Sometimes you can just go in with knowing and knowledge. Put in the right paperwork like I've shown in relation to the police interactions playlist in relation to notice of liabilities. Having conversations, putting both chiefs and lieutenants directly in their place, then moving forward with civil litigations and lawsuits, which I've done. It's all here on my channel for you to understand. Stand on your rights. If they violate you, take action. We'll get into civil rights violations and processes more soon, but right now all I've done is filed an amended complaint, and all I'm doing is waiting for them to respond. I filed it on the 3rd. Here we are on the 18th. We still waiting for a response. No response yet. The last one they didn't even hit for a motion to dismiss whatsoever. 12B motion. Why not? Because they can't dismiss the facts. The facts are the facts. You came up and arrested me with no probable cause whatsoever. So what are we gonna do here? Do you want to start talking settlement offers? Do you want to give me a call? I still haven't gotten a call. There's no emails. So apparently the alternative dispute resolutions are null and void at this point. There is none. So shall I move for a summary judgment at some point? Yes, possibly, but right now I'm waiting to hear a response to the amended complaint. There's no need to argue with him anymore. We do the Eddie Craig script. We stay by the script. You see the newest video with the no ID, the police interactions with Scott Stackle, which I'm going to be speaking to tomorrow. You'll understand that the Eddie Craig script works. The cop came up. We're not going to play the constitutional crap here today. I'm going to need you to step out of your car. We're not going to do this. We're not going to do that. I need to see your ID. Are you refusing to get ID? We need backup. I got one not complying. I'm complying, says Scott. I'm perfectly complying. You're just rushing me, bro. Why are you resisting? We haven't gotten to that point yet. Are you resisting? We haven't gotten to that point yet. And guess what ends up happening? He goes and walks back, writes the tickets. The other sheriff comes up, learns a little bit, honors his rights, makes a huge video out of the ordeal because he's stuck by the Eddie Craig script. Now all he's got to do is go into court, file an abatement. He don't even got to go in. Honestly, dude could just file an abatement and never show up. No commerce. What you gonna do? Prove the verified complainant. If you can't do it, what else you got going on? What else you gonna do? So, I see we got Chili from Delete Laws in here. Hey, Chili. Welcome. Glad to see you in here, brother. Yo, I will say, Chili has a wall that he has put up in relation to a game board that he is doing, and that thing is fucking impressive. I'm talking about impressive. I ain't gonna lie. Brother, congratulations on that wall. That looks like it's a lot of hard work. Looks like a lot of research went into that. And I'm sure whatever you are developing and whatever you come out with in that regard is going to be beautiful. And I would love to come down to California, and maybe you can invite me firsthand to come take a look. And I can experience the beautiful creation in which you've done. So, shout out to Chili in the chat. Shout out to Chili in the chat. Well, Chili, maybe we can help you with your federal court case, brother. That's what we do in Operation Wisdom. What do y'all say? If everybody's down for Chili to get some help in Operation Wisdom from everybody, y'all put a 1 in the chat. Y'all put a 1 in the chat right now. Y'all put a 1 in the chat if y'all think Chili should come into Operation Wisdom and get help with his federal court case. All on his own propria persona. Y'all put a 1 in the chat. Yeah, you see how this goes, Chili? It's all love over here, Papa Bear. It's all love over here. Yeah, come on over, bro. Again, you got to remember, we put it in perspective. What is a mastermind? Normal people think it's one person that knows it all. No, sirree. It ain't just me. You think it's just me out here? No, sir. I'm the spokesman for we the people, where all power is inherent. Knowledge is power. Wisdom comes from God, the great creator. And when we come together as a mastermind, as a wise dome, the power is unfolded. Realizations blossom. You think one can do it all? Oh, there are so many different perspectives of people coming into this, bringing their perspectives to empower all. It's beyond anything that I could ever fathom would come to fruition, and it's a beautiful thing. And I just want to congratulate each and every one of you, because it's, again, yo, this is us, yo. This is us coming together. It's crazy. It's so crazy. It's so crazy, y'all. It's so crazy. I'm going to give y'all an opportunity to listen to the court just for a little bit. We're going to take a quick break and let y'all listen to the court for just a quick moment.
Brief. Even a good faith claim to ownership of the property is not necessarily a defense to burglary. Burglary is simply entering or remaining unlawfully on a premises with the intent to commit a crime therein. In this case, the state has shown probable cause of that, and I would ask the court to deny the motion.
All right, thank you, Mr. Christensen. Mr. Reno, anything further on this issue?
The only thing that I would say, and I think I already stated this, so I'm just going to be really brief. The only thing that I would say about that is that the existence of the complaint, the existence of the dispute from the purchase agreement that was not recorded is only, it does not provide notice to Ms. Setzer because she's not named in the agreement. Mr. Carper is. And so the only person who would be on notice per the terms of the purchase agreement, which is in the complaint, would be Mr. Carper, who is also one of the defendants in the lawsuit. So for anyone other than Mr. Carper, the statute is pretty clear that there's no notice with respect to the purchase agreement. So there is no actual dispute of fact about who the owner of the property was on July 1st, because the default judgment quieting title was not entered until July 12th. So that's all I got, Your Honor.
All right, and again, as Mr. Christensen points out, the court is supposed to look at the facts that are presented here in a light most favorable to the non-moving party, and a decision in favor of Ms. Yates and Ms. Setzer is only appropriate if there's no genuine issue of material fact. I think that the arguments that are being put forth as far as what was recorded with the auditor, the timing of it, how the purchase and sale agreement was not recorded with the auditor, those are all wonderful arguments to be made in the civil case. But ultimately, that doesn't direct the court into a directed verdict here as far as the criminal case is concerned. In researching this, all the case law that I saw is that ownership is not a necessary element to the burglary charge, and all it requires is an unlawful entry into a dwelling. When you look at the probable cause affidavit, Ms. Setzer made the same claims to law enforcement that were on scene at that point in time, and they explained to her that they were very familiar with Ms. Matheson and that she had in fact residing at the residence for some time, and that Ms. Setzer was aware of this. I think there's evidence in the record that Ms. Setzer's claim to ownership of this property was also in question. So when you look at all of these things and you look at the analytical framework as far as the Napstad motion goes, there is genuine issues of material fact as far as ownership, whether or not Ms. Setzer was authorized to go into that. I have a sneaking suspicion that if the record was developed, that there would be additional testimony from the parties regarding what everybody knew about everybody's connection and involvement to this property. So at this stage, I think there is sufficient evidence to allow this to go to trial. So I'll deny the Napstad motion with respect to both individuals. So that leaves us as far as a status date. We've got a trial date currently set. Oh, I'm sorry. We still have the joinder motion. Mr. Christensen, I didn't see any opposition to that from the defense.
Well, Your Honor, we don't agree. We think Ms. Presley was in a completely different situation. I think it's pretty obvious that she wasn't claiming ownership. She was basically along for the ride. So we would ask that she remain separate.
Are there Bruton issues or anything else like that where she made incriminating statements or anything else like that?
No, there were not. I think basically my client thought that she was going with Ms. Setzer to Ms. Setzer's property. She had no knowledge of the underlying issue. She was, again, along for the ride. There were no statements because Ms. Yates had no knowledge of any of these underlying issues. Again, I explained that we discovered these issues sitting in my office late on a Saturday night. It was like, whoa. So I think she was basically an innocent bystander, and there's no evidence that there was a conspiracy. There's no evidence of anything other. And again, the statements that were made by Ms. Setzer were, "This is my property," and Ms. Yates was along for the ride with her friend to go to the property. There was no evidence that she had any knowledge at all about the ownership. If I go to some property with some friends and they say it's their property, I'm not going to go look in the assessor's file.
Okay.
So, and again, I think you look at Miss Yates as young. She's 25 years old, no criminal history. She had and there's no evidence she had any information other than she was going to this property with her friends. And at first blush, and with the information I found before I was advised of the quiet title, was that it was Miss Setzer's property.
All right. And then Ms. Torreno, your thoughts as far as joinder?
Your Honor, my client opposes joinder of these matters.
Man, they ain't talking about nothing. They really ain't talking about nothing. Yeah, they ain't talking about nothing. They ain't talking about nothing. What y'all talking about though? Diesel for We the People, nice to have you in here. Oh yeah, it's Mo. What's up, Mo? Rami in this thing. Chin Chin. What's up, Chin Chin? What's up? What's up? Let me see who's all in the chat. I want to shout out everybody again who gave a super chat. Y'all are beautiful people. Thanks for donating to the cause. If y'all don't know, I got something else going on too. Civil litigation. Really, it's a contract of breach. If I gotta really tell it like it is, we had a breach of agreement with a client that I had through my sole proprietorship. This dude breached our agreement. I don't know why he did that. I don't understand why he would do that. Really, I sent a cease and desist. Somebody was defaming me and just causing relationship problems with my client. And I sent them a cease and desist, and they ended up breaking the cease and desist, and the client ended up terminating our contract illegally. And so now I'm about to go through arbitration with that client, and we're going to be asking for $100,000 initially because I made a move from Portland to this area to ensure that I could work for the next 5 years for this client to grow this area that I knew would blow up. And I knew I'd make at least $100,000 a year. No problem. I've been doing that down in Portland with just residentials only. So coming up here to this area to get residential and commercial was a good move for me because I knew I'd get a lot more, and I have the whole region and area to myself. Well, they're still not operating correctly in relation to the contract. They haven't initiated arbitration or mediation. They haven't given me the aspect of their lawyers or attorneys' information whatsoever. So it's real problematic for them. And they're looking very bad on this aspect. But yeah, if they don't come through with that $100,000 in relation to the violations already for the breach of agreement that they've done and the harm and irreparable harm they've caused, then we're just going to take it to a civil matter for $500,000. Because again, I moved up here with all intents for a career move for 5 years. So yeah, we actually move forward in all kinds of angles. And again, I'm going to at least be able to be very transparent to everybody to let y'all know, what I'm doing, so y'all can see, and then, be able to apply it in your own situation and scenario. And it's really just never waiving your rights, always standing on your rights and your remedy and everything that you are, because you got to remember you are a creation of the Creator, and really all these companies are below you. And for some reason we've thought that they're above us, but they're not, and it just, again, comes down to knowledge, you dig? So let me shout out some people in this thing. What's up, Thomas? I see you in this thing. Papa, what's up, Danny, the Guru, Sin City, Jenna Weeks in this thing. Chris Himness, I see you. Pamela McClurg, I see you in this thing as well, girl. I know you've been studying. We've been talking. Doug Porter. All right, Doug. What's going down now? Who else we got in here? Slamming, jamming. I'm glad you've read the Federalist Papers, bro. That's good. We need people who have read the Federalist Papers, Chili. We need those type of people to come in and help us incorporate a lot of the deeper aspects that I've applied in my new book, Self-Govern, bruh. In my new book, Self-Govern, bruh, right? This is my new book, bro. This is so deep to me. I'm so proud of this, man. And we need to start incorporating a lot of the things that I've been able to figure out in relation to injunctions, in relation back over to or conjunction with irreparable harm, and the aspects, again, that we are all creations of the Creator, and that is the deepest and most significant aspect of what you can do to apply in relation to constitutional violations against you immediately when things are happening to you in the courts. Okay? Who else we got in this thing? Again, Ralph. Shout out my boy Ralph. Again, Joe in this thing. I see y'all. Christopher in this thing. Jack Herrera, I see you. Daniel Dodge, shout out. Shout out Mario Mendoza as well. Grateful Dabs, AK Audits. Jonathan, I see you in this thing. John Wick, let's fight back like you know it. Les Hornbeck, what's up, my guy? Too much M's. Lake Burton Bear, shout out. Troy Cook, I see you in this thing again, my brother, always attending. Copsar 5150 again, yes sir. Now let's read some comments. Stand on your truth, Chili. I like that. Tell them you got to stand on who you are, man. If you're not standing on who you are, you're gonna fail. You know what I'm saying? You got to stand on it, my guy. You have to stand on it. We multiply. Oh, we multiplying massively, very quickly as well. I agree. Have y'all seen the courthouse in Florida? Question was the property stolen? Nothing was stolen. Let's see what we got going on. We're talking about you, Willis. No, we're not done with the hearing. Luis is still waiting. We haven't even got to Luis. We ain't got to Luis yet. We're about to get to Luis in a minute, y'all. Be patient. It's coming. His is serious. His is real deal. This one's gonna be a nice, good talk with Luis. That's for sure. Okay. Jenna, oh yeah. How can we donate to you? All right, if you want to do any donations I gotta find the link, y'all. You know what? What I would do is I would listen. If you want to donate, oh yeah, it's Mo. I would go to CJW or bio.site/CJW and buy the book Self Governed Bruh. Let me give you something of value, please. May I be of value to you? Something that you can hold and keep on to rather than just donating. I mean, you could donate too, but can I give something of value, please? Like, take my book. I'm signing them. I'm writing notes in them and sending them directly to you as stickers. Like, it's coming directly from me. Like, it's going to smell like me. You know what I'm saying? Let me be of value to you, please. That'd be the best thing I can say. It's good to see everybody in here, y'all. Y'all are amazing. What's up, Juxtapose Art? Yeah, the court is still dealing with this other person, so we still waiting on Luis. Look, y'all want to see? Kind of just waiting.
Was making it, but since there was a holiday yesterday, I couldn't get anything on the docket, and I wasn't sure
I got it. I can
how
get
to proceed.
See, there ain't much popping off. We came in here at 1:30. It's 2:36 now. Still waiting on these people. The only other thing I could think of as far as, let me see something. If you just want to explicitly donate, the only other way I know how for you or anybody, I got something set up, but I got to figure out how to. Uh-oh. Am I just showing baby girl right now? I think so, huh? Where's the WebEx? There it goes. Okay. Hold on 1 second.
Oh, here we go.
Gotta do it ourselves. Well,
My newest book right now, signed copy directly from me, getting printed. Right now is 90. I think it said for 90, but that includes shipping and everything too. Signed copy. We getting stickers in there. It's all gonna be a signed copy. I'm gonna do some notes in there on certain spots
All right, so
for
Ms.
everybody.
Setzer, your
Turn
next
to a
mandatory court
just
appearance
open
is
up
going to be
each
on
one
March
and just
11th, and
randomly
that'll be at
pick,
9 o'clock.
look and find
And
something
then we'll
in there,
talk
put
about
some
that
notes.
March 26th
I wanna make it
trial
special for
date.
everybody,
Ms.
you know?
Yates, same dates apply in your case as well. Other than signatures, Ms. Nordvet, anything further in these two cases?
no, I'm just going to put down the status of March 11th and the trial of March 26th, Ms. Yates, and we can arrange to talk in between now and then.
All right, and then Mr.
Okay,
Christensen,
looks like
anything further in these?
we'll be moving forward with Luis
And is
here
there going to
soon.
just be a little quick generic order that does the joinder at some point?
Yes.
Okay, perfect. Okay, if I can take that. Okay, so then we've got Ms. Wilkes on camera.
This is a donation link too, the one I'm about to put in right now, y'all. And you can pick whatever you want. It could be $2, it can be $3,
And Ms. Wilkes.
it could be
is
$100,
here
it could be
in call number
$500, I think.
24-1-2333.
I'm not sure
Ms.
how
Wilkes,
much
are
you
you
can
able
actually
to
donate.
unmute down there?
I think so.
Okay, can you hear us?
I can, yes, sir.
All right, so this is on for recommencement. Looks like Ms. Wilkes
Oh, okay, I thought you were asking.
and seen in district court on the 14th. Mr. Reed, are
And
we
this one's
just
under
reserving
Mac
on bail for the
OS.
time being?
So I want to bring Mac OS, filters, close, Mac OS properties.
Folks, your attorney dropped off the call, so
Okay.
we'll try to get him back on camera as soon as we can.
Okay.
All right, so if you can just mute and hang tight, we'll get to you as quick as we can.
Yes, sir, thank you.
Ms. Udegaard, did we figure anything out from Mr. Kurd?
Your Honor, I need to speak with
Right.
your clerk.
Uh,
Interrupt her doing her
Okay, everything should be good. Yeah.
Okay.
At this moment. So I just need to speak with Mr. Hagopian, I believe had brought up the file. So I just need a few minutes to talk.
Okay, and I'm
Can you
conscious
quickly
of the
run
fact
down
that you've
what's the
got your
difference
family here.
between
I'm trying to
traveling
get to you as
and
quick as I
driving?
can, but I think your
Understand
case
the
is gonna
concept,
take some
but how do
time.
I travel
I'm gonna
versus
try to
drive?
keep things
When
moving.
you
I'm just gonna
travel,
take a
anytime
quick
that you're not
recess. They
using
can
the roads
talk.
for
Hopefully,
commerce.
we can get this figured
So
out. If
how
I
it
can get
works
the
is
other
the aspect
attorney,
that
and
drive
then
is a commercial
we're
term.
get to
So
your case.
drive
So we'll be in
includes
quick recess,
transportation,
and then
right?
Yep, of course.
Transportation involves
Okay, so you
transporting
do that and then
property
you're done?
or
Let's
goods.
not-
Yeah,
If
so
you're
Oh,
not
I thought maybe your
transporting
case was the one
property
that was gonna
and
take.
then
or
go back down to the
people
jail.
or goods for money or compensation on the roads, you're not driving. Okay? That's how it works. It's that simple. It really is. If y'all want something super simple as well to read and to understand and know, I mean, it doesn't break it down, but it does give at least a good, it gives you the truth. And this is a New Hampshire bill. Okay? This New Hampshire bill was brought forth back in 2019. I want y'all to understand this. And it was passed on the lower level and died in the Senate, okay? But in here, what it will give you is everything that you need to know in relation to the truth of the matter in and of itself, okay? Which is that you have a right to drive. They've already the court is not muted. It's muted now though. And yeah, man. So they've already validated everything that we're saying is right. If people don't understand that, I got 262 representatives over there in New Hampshire in 2019 voting that this is all correct, what they've put in this bill. Because in the bill, you can see what's been struck and what's been kept. You dig what I'm saying? That's what's crazy in and of itself. You got all these people out here telling us, oh, no, you don't have the right to travel. You have to drive. You're mandated. You're required. Bro, if you're telling me that I'm mandated and required to travel from point A to point B in relation to my right of motion, then you is telling me that I'm a slave. I can't be required or mandated to do anything, bro. There is not one thing that you can tell me that I am mandated or required to do. Because if you did such, that would include me being into involuntary servitude. And I am not a slave. So I don't get how they can come across and anybody can sit here, but it's required, Cameron. But they say so. And they're placing these charges against me. Okay, come in the Operation Wise Dome. Let's get to work. Let's get to work. Let's get to work. Let's get to work. We stopping it. We stopping it. We stopping all that jogging. We stopping it. We stopping it. We loving all that jogging because see how it always stops on me when things it starts popping off? I hate it. It's alright. We can slow it down. We about to have it go down. Luis about to get this thing popping, dropping, stopping. Hit them with an injunction, now they dropping. TRO, restraining in this thing. Y'all don't want to play. So we got to see what's going on because they being slow with it. Look at the family having to leave. Y'all don't even probably see this because, let's see, switch over the scene. Look at the family leaving. It really is a shame what we got going on here, man, with their family and everything. Travesty. Such a travesty. Such a travesty. They're doing my boy dirty. Doing my boy so dirty. We're waiting. We are patiently waiting for you, Luis. I want everybody in the chat to say, we support you, Luis. We support you, Louis. We the people are here together and we support you. Y'all let them know in the chat that we here supporting you, Louis. You got 75 people here waiting on you, bro. We waiting to see what's going down. We support you, bro. We here together, bro. Strong, bro. They talking about Mr. Christensen represents the people. No, we represent the people. We represent the people. We are the people. For we are one, bro. We support you, Louis. Y'all flood the chat with we support you, Louis. Y'all flood the chat with we support you, Louis. We support you, Louis. Y'all flood the chat. Y'all flood the chat. We support you, Louis. Flood the chat. Come on now. Y'all flood the chat. We support you, Louis. Come on now. Flood the chat for real, y'all. Come on, flood the chat. We support you, Louis. Come on. You want this kind of support when you are in trouble, right? Don't you want this same kind of support when you're in trouble? When they're coming against you with false allegations, when they're out here violating your constitutional rights, don't you want this same kind of support? I know I do. Flood the chat. We support you, Louis. And we're going to do this for every single person. Every single person that wants it. This is egregious, bro. We have to stop this. We the people, we're growing, bro. It's about us. It's not about them anymore. It's about us, and it's about unity. This is what unity looks like. This is what a great nation looks like. Do you see this? This is what a great nation looks like. This is what we're coming with. We're coming with knowledge, power, intelligence, wisdom, kindness, compassion, integrity, morals, respect, and a knowing of who we are. I am. You are. We are us, where all power is inherent. There's no more stopping this, man. Knowledge and wisdom. And wisdom comes from the great creator. And we know this. I can have all the book smarts I want, but if I don't get the wisdom that comes from God, then none of it is possible. I just want to, say a quick prayer. I don't fall into no religion, so I'm just going to do this. We got to pause the music for it. We're going to do a quick prayer, y'all. Yo, great creator, Father, Mother, all-encompassing, all that I cannot understand or comprehend or even fathom, knowing that I have been here before and I will return again. Yet you have instilled a moment and purpose in this life and time to bring forth everything that you desire. I recognize it. I recognize that we have a group of people here before us today that are willing and able to stand in truth and honor and respect, with morality and compassion and unity, in abundance that we bring forth for Louis today, that he speaks the right words, that you put it within each and every one's soul, every aspect of which is spoken in truth and harmony. We ask that you allow this proceeding to touch many people. We allow that you work in mysterious ways that are unknown to me beyond, in the everlapping and overlapping and encompassing framework that is so far beyond recognition that I cannot even perceive. But I do perceive the words that are spoken, and when asked amongst many, there it becomes truth and fact, and realization and visualization comes forth. And I thank you for that. And I realize that. Yo, my boy got this, yo. My boy got this. Wisdom gonna be bestowed to my boy today. For real. For real, for real, for real. This gonna be good. Like, I can already feel it, because I know he ready. I know he ready, man. I know he ready. I know he ready. I know he ready. going to take a quick moment.
That's fine.
Okay, so we'll set trial for April 9th, and then what if we did a status conference March 4th or 11th at 1:30?
I would ask for March 4th.
All right, and Ms. Udegaard, I know you're just filling in for Mr. Reed, but well, I guess we'll just use March 4th for the time being. So Ms. Wilkes, your attorney, Mr. Reed, had to step away to another court for a hearing, but he'll be in touch, and then if there's any motions that need to get brought back before the court, he can handle that.
Okay.
Okay. All right, so we have March 4th for status and
Yes.
April 9th for trial. Okay, thank you.
Yes. Anything further we need to do for Ms. Wilkes, Ms. Udegaard?
Not this time.
Mr. Christensen? All right, thank you, Ms. Wilkes. I'll see you in a couple weeks.
Thank you.
Okay. Jennifer, did they come up with something on Curd? Okay, perfect. Okay. Mr. Hagopian, do you have Mr. Hearing's files?
Yes, sir. Ready.
And then do you have minutes? Okay, so Mr. Hearing, if you want to come over to a microphone, sir. You've got 3 matters that are currently pending that are in warrant status.
Uh-oh, warrant status, but he's
Computer's
at
being
court.
Exceptionally slow. Cause numbers 23-1-216-33.
For all you people wondering, warrants incoming to court. He's not under arrest.
Was that there was some plumbing issues and temporary housing that moved you to a different location. Mr. Hagopian, is the state objecting to this request at this point, or what's the state's thoughts?
At this point, Your Honor, I'm filling out the quash form, but there's a section that says the undersigned moves for an order quashing issued in this matter for the following reason. And I don't know what the reasons are. So want to have warrants, but
No. There was a declaration filed on February 10th, and Mr. Reno indicated that Mr. Hearing was living in a location in, I think over on the coast, correct? Pipes were frozen, apartments got flooded. They moved him into temporary housing, and he was not able to access his phone. Once he reestablished contact with council, she tried to get this set up as quickly as she could.
then
And
I have those words.
we were set on for last week, but unfortunately getting transportation to Colville from the Seattle area turned out to be a little bit more complicated than we initially thought, and he wasn't able to get here until this week.
All right, and then do we want to recommence dates at this stage or set a recommencement?
I would prefer to recommence today because I don't want my client to have to drive all the way back out here again just for recommencement.
Okay,
Because
so
still
I think
resides
that's
on the west side. Sorry, my camera is
economical.
vibrator.
So with multiple files, that'll give us 120 days for speedy trial, giving us an outside date of June 18th. Mr. Hagopian, any thoughts or preferences on when we should schedule trial?
I'd say if we can, we should schedule it in no later than May. So maybe May 28 or 21.
Okay, Ms. Torreno, would a May trial date be acceptable?
May will work, except that I'm out of town the 14th. So the rest of May is fine.
Okay, so we could do, say, the 21st?
Yes, that would work for me.
And then what about a status conference? Do we want to do that early April?
Sure,
Say the 1st?
that will work.
And is that a good date for you, Mr. Hagopian?
It is, Your Honor.
All right, and then Mr. Hearing, can you be back with us on April 1st? Okay.
In person here?
It could, if it's just another one of those check-ins, by phone is fine. But if there's a resolution or something happens that we need you to be here, you're in good contact with Ms. Torreno. So just, yeah, be in touch with her and then she'll tell you if it has to be in person or not.
Thank you, Your Honor.
All right, so if you want
Say
to,
the outside date was, Your Honor.
June 18th.
Thank you.
So if you want to grab a seat, there's going to be several forms for you to look at and then we'll go from there. All right, thank you. Okay. I think that's everybody. Mr. Ochoa Ibarra, if you want to come on over, sir.
And I believe that was the last thing I had.
Yes, I
Unless-
think that does it,
unless
Mr.
something
Reno.
has-
Thank you.
Thank you very much. And thank you to the court and to council and especially to Ms. Nordvet for dealing
And
with
Mr.
this while I am.
Mr. Reno, I will be here all day Friday. If there's anything else I can do besides the plea, let me know.
Thank you. I'll let you know. I appreciate it.
Okay.
Here we go.
Thanks. I'll try
Okay.
and.
Okay,
Bye.
get off. Bye. Yes.
Don't worry about it so much.
All right, so this is case number 24-1-33233. This is on for a status conference and pretrial motions. Looks like the state has filed a 3-5 motion. Mr. Ochoa Ibarra, you filed some additional motions. What are you anticipating as far as your motions getting heard today?
Oh, well, first off, I'm Luis Armando, the natural man, and I don't waive any rights. You know, I actually wanted to go over challenging jurisdiction,
No, that's not before the
subject
court.
matter jurisdiction.
That's, you've already briefed this. We've already had this conversation. The motions that you filed are the only ones that we're going to be discussing.
I can't go over any of that, even though it says that I can challenge jurisdiction whenever.
No, it's already been decided. Judge
Well, then
Ruiz
can
already
I
ruled
can I
on
at
that.
least bring up corpus delicti that there wasn't any?
Anything that's already been decided by motion practice, we're not relitigating today. So of the motions that you filed on February 10th, what is it that you expect we're going to accomplish today?
Well, just that there was no corpus delicti at all. Like I got some Washington case law as well that says corpus delicti usually consists of 2 elements.
Okay, of your motions that were filed on February 10th, which one would you like to address first?
The constitutionally applied one.
Okay, Mr. Christensen, are you ready on that one?
Yes, Your Honor.
All right, so I did have a chance to read that. I got some notes, so I'm ready to hear what your thoughts are on that one.
Well, it was towards Christensen, so he would have to prove.
No, this is your request that this is unconstitutional as applied to you. So under the case law, you bear the burden of proof of establishing that.
Yeah, okay. Well, yeah, like, we know that the Constitution is the supreme law of the land, and I wanted to bring up the fact that, that there was definitely a violation of my rights. I did, file all the paperwork that you've suggested as well. Just like that, the Constitution, is the one that we're going over right now, and I did want to also apologize for last week. I know that I shouldn't have, just gone out like that. So I do apologize for that. But yeah, like I know that my constitutional rights were actually violated, and I wanted to address that issue because we know that everybody here, well, at least most people in here actually do take an oath to uphold and support the Constitution, and I want you guys to know that we need to uphold the Constitution for the rights of the people. I'm part of I'm part of we the people, and I think we should all come together and be able to know that we can't be violating people's rights like that, and we can't allow the cops to violate people's rights. That's why they're getting power hungry and doing these types of things, and we need to continue and know that we, the Department of Justice, that they protect this type of stuff, and I don't know what else to do but to go to them, and if I have to file a report with them, then that's going to be my last resort to do, is because I've done everything I can to show that I haven't violated any rights of anybody, and there is no injured party or any of that, and it hasn't been proven that there is no ill will, no intent to defraud or injure. None of these things have been proven, and I want you guys to consider these things, because I know you guys uphold your that oath that you guys took, and it's in support of the Constitution. Anything that goes against it is null and void. And any statutes that Congress or legislature has in place that violate life, liberty, and the pursuit of happiness goes against the Constitution. So we need to know that we all have rights, and the Bill of Rights is there, for the people, and the Constitution is there to stop any infringement on anybody's rights, and it's there to also, not allow the government to usurp its power as well. And I know that the Constitution is the only thing we have right now to protect us from the government, because it was a contract from we the people to the government, and I think it's not right when we see these things get violated, and there is no remedy for the people, but all these agents, because each and every one of you guys are agents, to the Constitution, and you guys need to uphold it and protect it. And I want to see the rights of the people be upheld. I don't like seeing people be taken to jail for nothing. Like just like I said, corpus delicti is out there. And it's even upheld in Washington. Like that's one of the main things that it's upheld in Washington is corpus delicti. But I really want you guys to consider the Constitution being there, and nobody usurping that power, because there is a supremacy clause as well that nobody can try to step on, and as we know that all these statutes and acts, if they go contrary to the Constitution, we already know that they're null and void. And my rights. I've proven, even with the affidavits that I put in, that, you know, I have a right to travel and all these other things, you know, like I don't, you know, just even personal liberty, you know, personal liberty, if you look up just the definition of personal liberty, it's the right of locomotion. It's been upheld plenty of times, even the 14th Amendment, like all these things are there to protect us from government coercion and intrusion, and you know, all these things. You know, my family has been having to go through this, you know, not just me but my family as well, for 5 months already. You know, I don't think that that's just for me having to go in and out and having to take the time out of the day to, instead of studying and you know, doing other things, because you know, I go and try to travel different areas, you know, like DC and those places. Even like the inauguration, like we went to go hand out books over there, you know, to wake up the people to the truth. You know, like it's all like literature that you know is showing the people that the end time is coming. You know, and we're trying to wake up the people. You know, we can't allow these things to continue to keep going on, and you know, I really want you guys to understand that I'm not the ens legis or any of this stuff. You know, that's on paper. Like, you know, I'm a living man. You know, that has rights, and the Constitution. You know, if anybody violates those rights, the Constitution is there to go against the government and any type of intrusion that is put on the people. You know, and I really want you guys to consider this. You know, that there's so much people hurting out there, and for the people that take an oath to uphold the Constitution, for them to be causing that type of hurt to the people when they've done nothing wrong is definitely going over their powers. You know, and even the 10th Amendment shows that you know, there is police powers, but it's all within the Constitution. Anything that goes outside of that, then it definitely, you know, shouldn't be considered at all. Like it should be, you know, there should be consequences for people that try to go outside the Constitution. You know, and you know, I really love all of you guys. You know, like I want you guys to uphold what you guys took an oath to, and I know that in your down deep in your guys' heart, that's what you guys want to do. You know, like don't let this be, you know, a court of equity and or any of this stuff that you know, just taking, you know, people's monies and you know, doing all these things, you know, when we know that it obviously goes against the Constitution. And you know, that's why I want to, like, I know that this is, you know, criminal, and we have to be under the common law. You know, it's under, should be under common law, shouldn't be under anything else. And I want you guys to know that you know, that we need to be there for each other, and you know, not cause harm to anybody. Like, you know, it couldn't cause harm even just by having to come to court when there hasn't been any damage or any, you know, hurt done to anybody. Like I also you know, there was a few RCWs as well that I found really interesting, because it says that the people, this is RCW 4256.03, says the people of the state do not yield their sovereignty to the agencies that serve them. The people and delegated authorities do not give their public servants the right to decide what is good for the people to know and what is not good for the people to know. You know, like it's in your guys' own RCWs, like, you know, that the Constitution has to be upheld. Like we can't just throw it to the side and let it just be words. You know, like the founding fathers, like all of them, like they've shed a lot of them shed their blood, you know, to for the rights that we have today. You know, and if someone's not, you know, it's that simple as long as someone doesn't hurt nobody, cause damage or any of that, you know, to anybody, then and they should be free to do, what they need to do, as long as they don't go or step on the rights of anybody else. And but I've been wanting to I've been coming to the court, to stand up for the people. And I think that's what a lot of us need to start doing, is instead of condemning other people for petty offenses that don't even cause harm to anybody, and just the fact that the Constitution is not being upheld inside of a lot of the courts because of the procedures that are being done as well. Like you guys know that you guys can't hold me to the same standard as an attorney, or any of that. Like, we should have the right to come into the court and speak up and be heard. I think that there's a lot of things that need to be considered here. You know, just like I told you guys, that the rights of the people is what matters here. And when someone continues to violate someone's rights, when they brought it up in court over and over again, and they're not being heard, it really makes you question the court, and the oath that they've taken, because first and foremost, that's what it should be about. It should be about the Constitution and protecting the rights of the people. Like, we need to love on others and show them that we care, and not throwing people's into jail and separating them from their families, causing all this like irreparable harm as well. Like, there's so many things that can be caused just by these things, and if any statutes and acts are oppressive or coercive, they shouldn't be upheld. We need to to be there for the people and not cause stress upon them or anything that can violate them in any way. Not just them, but their families. That I'm the main provider for my family. If I were to be separated from them, like, they got nothing. Like, not just that, but just the fact that all my my cars and my trucks were taken and all that, and that really caused some big damages, to each and every one of us, because we didn't have a ride and we had to figure out what we can do. And even my wife just having to be outside and not have a ride, and the cops just left her there. We just barely moved up here not too long ago. Like, for all that stuff to happen, it is causing damages and irreparable harm to each and every one of them because of this situation. Just because you guys think that I need to have certain paperwork, to be able to travel when the Constitution has upheld it. And there's so many, it's a part of life, liberty, and the pursuit of happiness. We need to uphold these things and be there for each other. We got to stop doing these things that violate the people and their families. There's so many people that don't even have money to do certain things, and just as we've seen earlier today here with the people that were in here.
And I don't mean to cut, I need you to focus on the facts of your
Yeah,
case.
sorry about that. Yeah, so yeah, like, the Constitution is something that just that we need to all uphold. There's too many people that have lost their lives, over this, and shed their blood just so that we can have the rights that we have today. We need to continue to be there for each other, and that's how the people here in this valley are gonna start putting trust in each and every one of you guys.
Okay, again, focus on the facts. So the crux of your argument is you don't think that the state should require you to license your personal vehicle to travel, correct?
Yes.
And because the state's theory is that you had the license plate that you had on the car, that forgery statute should not apply to you because it infringes you on a constitutional level.
Yes.
Is that basically?
Yes. So yeah. So that. Thank you for bringing up those points. But yes. this has been upheld plenty of times, even just as we've seen, personal liberty. We look up the definition of personal liberty. It's a part of life, liberty, and the pursuit of happiness. Like, if you take away and try to demand someone to say that they need certain documentation to travel when it's been upheld plenty of times, and showing that it's all commercial. Like it only applies to those that are using the roads for a commercial capacity, or for using the roads as a place of business. And this has been upheld so many times. I've spent days on just looking up case law. Like I'm sure you guys seen the affidavit and the memorandum in support of the affidavit that shows all of this stuff, that we have the right to travel. And it's not by foot, because so many people try to say that's by foot. But if you just look up the definition of personal liberty, it says the right of locomotion. And yes, that plate that I have, you guys are still, if someone were to steal my truck or whatever, all I would have to tell you guys, like, oh, it's a truck with this plate, and you guys would know, like, okay, well, now we can distinguish it. So there is no harm by me having my own personal property and my own personal things that I choose to put on my truck to identify it, as my own. This shouldn't be a crime to be able to practice the right that each and every one of us have. Like, the legislative intent, what was for those that were, it was a excise tax for those that were using the roads for gain or for profit. This has been shown very clearly through so many of these how you guys say, the points of authority. There's been a lot of case law showing this stuff, but not just that, because case law, they're just all opinions. Like, we have to go back to the Constitution and the Bill of Rights, the Declaration of Independence. All these things, is there to uphold the people's rights, and then show that government should not infringe on any of those things. We should be able to do these things freely and not be encumbered by, or even harassed by anybody. And yes, like my plate, like how you said, like that there is there is no ill will, there is no intent to defraud or injure. Like, there is none of these things, but the state continues to point back at it, like if there is these types of things, but there isn't. Like, there's no proof at all. It still hasn't been proven to this point, and it can't just be, the state can't just be continuing to try to say that oh, well it's because he doesn't want to pay these taxes for the roads and stuff, and that's not true. Like, it's because I have a right. I comprehend that yes, the driving is a privilege, because that's for those who are using the roads for profit and gain. Like, yeah, I get that, but it also says in the Constitution that the people have the right to travel, and not not by foot. It's by locomotion. It's the right of locomotion. But yeah, I just know that we need to uphold our rights, or else we're going to lose them very soon. And I'm not causing harm to anybody by doing this. I haven't even wrecked or gotten into any accident at all the 33 years that
No, and again, we're getting too far off what we
Okay,
need to
sorry
talk.
about
So
that.
anything further on the license plate issue?
Let me think about it real quick. So yeah, I guess just the plate itself. It's not forgery. It doesn't even fit the whole thing with forgery. I didn't get a government plate and try to alter it in any way. Like, this is something that anybody can get online and custom make it how they want. Like, I only chose state of Washington. It didn't say Washington in all capital letters. Like, there's some places that say Washington in capital letters or Washington State. I chose the state of Washington because that's where I live. I wasn't trying to do anything to forge anything at all. Like there has to be intent and to defraud and injure. There has to be some type of damage done to someone else by that. But there wasn't anything like that. So I just asked that the state prove these things, and if it can't, then I motion to dismiss for failure to state a claim, in which there can be remedy to, and you know I think that's pretty much all I got.
All right, Mr. Christensen on this point.
Thank you, Your Honor. This is the defendant's third motion to dismiss pretrial, and I believe that at least I didn't hear anything that was particularly new in today's argument. All of these issues have already been ruled on before. The state has shown probable cause for each of the charges. The defendant simply asserts this is unconstitutional without giving us a real basis. He simply gives us the entire Constitution. I think there has to be a specific basis, or the defendant says that one of these laws are unconstitutional, which none of them are. The requirement to register a vehicle is every state in the union, as far as I know. It is certainly the law on the books here. The defendant's right of travel is not being impacted. All he had to do was pay a fee, register his vehicle, and he could travel on public roads paid for at taxpayer expense. So I don't see how this infringes on any right that he has under the Constitution. The bottom line is he simply doesn't want to pay these fees for one reason or another. He doesn't respect the state laws, and he feels at license to violate them. He wants us to prove it. We're happy to prove it at trial. I would ask the court to deny the third motion to dismiss. All of these issues have already been ruled on.
All right, and the constitutional one's a little bit different than what's been before. I'm not going to rehash the injury because that's what we talked about last time. And I denied the motion, and I did find that the state had found or appointed me to sufficient authority as far as the injury and the forgery. Also recited applicable case law that when one fabricates or puts off as true real government documents, that does qualify as a forgery. And there was this case citation at that hearing.
But this wasn't a government document, though.
Let me finish. So bottom line is you believe that your right to travel allows you to put a plate on your vehicle that for all intents and purposes is meant to look like a real license plate. And that's their theory. And that's the theory that they're going to put in front of the jury. And I know that you disagree with it, but RCW 4616A030 states that vehicles must be registered as required by the statute and must display plates or decals assigned by the department. Further states that it's unlawful for a person to operate any vehicle on a public highway of the state without having in full force and effect current and proper vehicle registration and displaying license plates on the vehicle. That's the statute that you take issue with. So then when we talk about a constitutionality as applied to you, that doesn't necessarily invalidate a forgery, just indicates that under your particular fact, you believe that the Constitution allows for you to do this. So Washington has actually upheld that and has said that the state of Washington requires drivers to have valid driver's licenses to operate motor vehicles on public highway, and that this requirement is part of the state's police power to ensure public safety and welfare. This is City of Spokane versus Port.
Well, like I said, the language that is being used there is a driver. It's not saying traveler.
Hang on. So then you go into the federal world, and it says the right to travel includes both interstate and intrastate, so in and out of the state, is fundamentally protected by the U.S. Constitution, and that any classification that penalizes this exercise must be narrowly drawn. And so then when you get to the actual federal authority, you have multiple citations that talks about the requirement of all individuals, not just commercial drivers, but all individuals, private as well, to license vehicles. You have Calentech versus Burrow. This is this is 60 Federal Supplement 115-1. Matthew versus Honish, 233 Federal Appendix 563. Hendrick versus State of Maryland, 235 US 610. Carly and Hamilton versus Nook, 38 Federal 2nd 1033, all the way back to 1929, which is, I'm guessing, right about the time cars became prevalent. So I know that you disagree with it, but
Yeah,
the
but
US Supreme Court has interpreted that it is a valid exercise of police power to require people to license
But see,
vehicles.
that's the thing that you're not understanding is that
Okay, I listened to you. Now it's my turn.
I know. Then I'm talking now because you.
No. I'm ruling. Your motion is denied. The statute as applied to you is constitutional because there is a valid requirement that has been upheld federally to require individuals to license their vehicles. And the requirement for government to impose reasonable restrictions on licensing has consistently and repetitively for the last 100 years been upheld as a constitutional limitation on your right to travel. So which motion would you like to take up with next?
Well, just can I answer back to you at least?
That's my ruling. We're not going to argue.
No, but can you at least listen though to what I have to say?
Okay.
Yeah. So like if we look at the federal definition for driver, it says one employed. If we even look at it, even in the Black's Law Dictionary, it says one employed.
And the case law that I cited refers to both commercial and private vehicles. So which motion are we taking up with next?
You know, I got case law as well that shows otherwise, but
Which motion are we moving on to next, Mr. Ochoa Ibarra?
we'll just go to the next one that's there.
Which is what?
The what is it called?
The appeal?
Is that the only one that's there?
The only other one that I had that was a motion was your motion for interlocutory appeal and request.
Yeah, the interlock.
So this, again, we've talked about this, and I'm gonna again encourage you to rethink your position on an attorney. This is something that's done at the Court of Appeals. This is not something that I do. I do not grant interlocutory appeal. Did you file anything with Court of Appeals?
I didn't.
Did you pay a filing fee with the clerks?
The what, clerk here or to
Yes,
the?
here.
No,
Did you make any arrangements to get your appeal filed?
no.
There is no appeal. So until Court of Appeals renders a decision that they've accepted the case, which is something that's done at their level, not at mine, there's nothing for me to stay. So you have to initiate this. There's a procedure. There's forms that you have to use. Those have not been followed. So I cannot grant you the relief because that comes from a higher court rather than myself. So are there any other pretrial issues that you'd like to discuss today?
I don't think so.
All right, so trial is tomorrow morning. Are you ready to proceed to trial?
Yes.
Okay, so then we have our 3-5 issue. That was the only pretrial issue that I saw from the state's end. Is that correct, Mr. Christensen?
Would there be any way to like just continue it a little bit longer just so I can be able to gather just a little bit more stuff?
What stuff?
Just for pre-trial, I mean, for the trial.
What stuff?
Just pretty much getting all my questions together and everything that has to do with putting things for the trial hearing. I mean, for the trial and for the things that I'm gonna have to be speaking on and stuff.
Mr. Christensen? A trial, essentially, if I understand correctly, it's a request for trial preparation.
Judge, we've got all of our witnesses subpoenaed and we're ready to proceed. This case has been going on since October. It's a pretty straightforward case. I don't know why preparation could not have been done up to this point. But we're ready to go.
Any response?
Well, you know, there's been a lot here, you know, especially with my family and the things I'm doing. And, you know, I do need some time to at least put some stuff together so that I can be able to, you know, be prepared for what's for tomorrow. And, you know, I don't think that, you know, it's sufficient time for, you know, because there's so many things I had to take care of as well. Like, you know, I have to be there for my family and do other things that, you know, with ministry and things like that. And, you know, this has been a big burden on all of us. You know, it's been going on, I know it's been going on 5 months, but, you know, if I can just please get just a few more days, you know, even just next week at least,
I'm not able to do next week. And here's the problem that I have is earlier this hearing, you're arguing about the harm and the prejudice that this has caused for your family while this case has been pending, and you've made that argument repeatedly.
Yeah.
You've known about this trial now for some time. This is not a surprise to you. This has been scheduled for some time. You're the one who's wanting to do this. If you wanted to rethink your issue on counsel to try to get an attorney, I'd be inclined to screen you for a public defender if that's the point that you want. I again strongly encourage you to rethink that position, because I'll tell you that on a felony charge, I know you don't agree with it, but if things do not go the way that that you want them to go, there are certain things that I'm required to do and certain presumptions that happened if things end badly for you. So again, I'm not inclined to give you a continuance for trial preparation. You've known about this for, I think several months now. We talked about it at last hearing, and we
Would,
did not.
would I,
move the
would I
trial.
at least be able to bring my counsel with me?
Who's your counsel?
So I should be able to bring at least counsel with me. So,
An attorney?
or what? It's pretty much just like the Constitution says that we should be able to bring a counsel with us.
No, the only individual that's going to be sitting with you at trial is going to be a licensed attorney. If they're not a licensed attorney, we're not having anybody assisting you through trial.
Um, Yeah, it's because I know that, getting an attorney and stuff, like, you pretty much become a ward of the state, and I'm not trying to,
Okay, all right. I've tried to talk you out of this repeatedly. You're choosing to represent yourself, and that's your prerogative. Trial's going to start tomorrow. The only other issue that we have today is the admissibility of any statements that you made to law enforcement. Did you get a copy of the state's 3.5 CRR 3.5 motion? Was that served on him, Mr. Christensen?
Yes, it was.
All right, so pursuant to Criminal Rule 3.5, I need to inform you that you may but need not testify at the hearing regarding the circumstances of any statements that you made. If you do testify at the hearing, you will be subject to cross-examination with respect to the circumstances surrounding the statement and with respect to your credibility. If you testify at the hearing, you do not waive your right to remain silent during trial. If you do testify at the hearing, the jury will not be told that you testified at today's hearing unless somehow the testimony from today's hearing becomes relevant at trial. So, Mr. Ochoa Ibarra, the purpose of this hearing this afternoon is to determine whether or not the circumstances around the interaction that you had with law enforcement are such that I can allow statements that you made during your interaction with law enforcement. So you're aware, I guess, on the body camera that there were statements made during that interaction.
Yeah, well, that's another thing that, my Miranda rights were never read to me.
Okay. And that's one of the things that I have to address today is whether or not statements that were made during that interaction, and the state laid out the analytical framework that I have to take into consideration. So it looks like we've got Detective Feldner. He's going to testify. You can cross-examine him, but the questions only relate to that interaction. We're not getting into the facts of the case. We're determining if that interaction was appropriate and whether or not appropriate in the sense, did it trigger Miranda? Okay.
Right.
Mr. Christensen, do you wish to make any opening, or do you want to just jump into testimony?
We just like to call Detective Felder.
All right, Detective, if I can have you come up, please. If you could raise your right hand, do you swear or affirm that the testimony you'll provide the court in this matter will be the truth, the whole truth, and nothing but the truth? Yes, sir. Thank you. Please have your seat. And if I could begin by having you state your full name for the record and spell your last, please.
Travis Feldner, Feldner.
All right, Mr. Christensen.
Thank you, Your Honor. What do you do for a living?
I am a detective for the Stevens County Sheriff's Department.
And how long have you worked for the Stevens County Sheriff's Department?
About 11 years.
And have you been a detective the whole time?
No, I've been a detective about 3 years.
And do you have prior law enforcement experience?
Yes, I graduated the Idaho Police Officers Academy in 2000. So I've been in some type of law enforcement since 2000.
Do you work for an agency in Idaho?
Yeah, Idaho Department of Fish and Game.
And did you have to do a some kind of an equivalency academy for Washington?
Yes, when I became an officer here in Washington, I challenged the equivalency and passed.
And so what are your present duties?
I'm the major crimes detective, so any felony stuff is what I deal with mostly.
And before you were a detective, what were your duties?
I was a deputy, road deputy.
Okay. And do you have a familiarity with the requirements of giving Miranda rights?
Yes.
And when do you provide that warning?
When they are in custody and I am asking interrogating questions, but they are in custody, like in cuffs or not free to leave. Yeah.
What was the last thing you said?
They're in cuffs, not free to leave. Yeah.
Not free to leave?
If they're in custody, they're in cuffs. Yes.
Okay, so what I wanted to ask you about specifically was October 6th of last year, 2024, around 12:30 in the afternoon. Were you on duty at that time?
Yes, sir.
Okay, and where were you located?
I was at the Spoko gas station eating lunch in Chihuahua.
And did you have occasion to speak with Mr. Luis Ochoa Ibarra?
Yes, I did.
Okay, and do you see him here in the courtroom today?
Yes.
Could you point to him and describe what he's wearing, please?
I'm sorry.
Could you point to him and describe what he's wearing?
Black sweatshirt, black pants, black tennis shoes.
Your Honor, can the record reflect the witness identified the defendant?
It will.
So can you describe how you came into contact with the defendant?
So I had a case back in August of a theft of an excavator. The suspect vehicle was a black truck pulling a car hauler type trailer that witness had seen steal the excavator. So while I was eating lunch, when I just happened to look up and I saw a black truck pulling a car hauler trailer turned off of Highway 395. I saw it just as it had come off. So I thought, well, I'll go look and get the license plate and just kind of run it and see if it had anything to do with maybe the suspect in my case. So I immediately went out, got in my truck that was parked in the back. I drove around. When I came around, I saw Mr. Ochoa get out of the driver's seat. So I went around the pumps to the back of the vehicle to get a plate off the trailer so I could run it. And that's when I noticed there was no plates on the trailer, and that when I went to make contact, I noticed the fictitious plates on the vehicle.
Where was Mr. Ochoa Ibarra when you made contact?
He was at the gas pump.
Okay. Had you turned on your lights on your car?
No, not at that point, because I was just wanting to basically run the plate. And then by the time I realized there was no plates, I was already out of the vehicle. So no, I did not activate my lights.
Okay, so did you have a conversation with Mr. Ochoa Ibarra?
Yeah, so I walked up to him and I said, "Hey, how you doing?" I think I told him who I was, and I said, "Hey, you don't have any plates on your vehicle or on your trailer. Do you have any identification?" I was in full uniform and a marked rig at that point.
Okay. And did he provide you with any identification?
No, he stated that he was not committing any crimes and that he was not going to provide me with that information.
Okay. And how long did you talk to Mr. Ochoa Ibarra for?
Me personally, probably 10, 15 minutes at that point until Officer Smith showed up. When she showed up, I went over and started looking at the VIN of the vehicle and trying to find a VIN on the trailer at that point. So I knew what I had going.
Okay. And where was Mr. Ochoa Ibarra at this point?
He was still standing at the gas pumps or right around the front of the vehicle, his vehicle.
Did any other officers speak with Mr. Ochoa?
Yeah, Deputy Lee arrived and talked with him as well. I know Officer Smith had talked to him, and then Sergeant Swim had showed up toward the end and chatted with him as well.
At any point during any of these conversations, was Mr. Ochoa placed under arrest?
No,
Was he at any point in handcuffs?
No, not until after I had told him he was under arrest at the very end.
And did he ever ask to have an attorney present?
So when I advised him he was under arrest for the forgery, I placed him into cuffs. I put him in the back of my vehicle. I immediately read him his Miranda, asked him if he understood him. He said no. I started to read him again. And then that's when he basically said, I'm not going to say anything. So then I didn't ask another question.
Okay. So how long had you had this whole interaction taken before Mr. Ochoa was actually placed under arrest?
Probably about an hour and 15 minutes, hour and 20 minutes, maybe. We were standing there.
So after he invoked his Miranda rights, were any more questions of Mr. Ochoa asked?
None.
So all of the statements in your report that you attribute to Mr. Ochoa, those are all pre-arrest?
Yes.
Thank you. I have nothing further.
All right, Mr. Ochoa Ibarra, any cross-examination questions for Detective Feldner?
Yes. Can you please state your full name, rank, and current position with Stevens County Sheriff Department?
So I did that already. Do I need to do it again?
Sure.
Detective Travis Feldner,
And your
Stevens
rank?
County Sheriff's Department, detective.
Okay, you're a detective. And then how many years have you served in law enforcement? And have you received training specific to RCW 9, the forgery?
Judge, I'm going to object. That's a compound question.
Yeah, you got to ask one question at a time. And remember, we're not arguing the facts. We're arguing whether the circumstances about whether or not you were under arrest and if Miranda
Okay.
was needed to be read. So
Yeah.
you got one question at a time.
Okay.
Yes.
I'm sorry, can I take a brief recess so I can restart?
Yeah. I guess we can just stay out here and you can restart it. Okay. Is it acting up?
Yeah, it's just being so slow that I can't even.
Okay. Good. All right, go ahead.
So, at any point of the interaction with Luis, was he free to leave?
No, he was detained.
Okay, and do you know anything about like a subject is physically deprived of his freedom of action in any significant way? You know any of that?
I'm not familiar. I'm not sure what you're asking.
Yeah, that if a subject is deprived of any physical freedom of action in any significant way, then do you like are you aware with any of what that means?
That means we're conducting an investigation.
So when the defendant was not free to leave, would that be depriving him of any freedom of action in any significant way?
Restate your question.
That if if the defendant was not free to leave,
Mm-hmm.
because you said that he was detained.
Yes. He was detained.
Was that depriving him?
What's wrong? Check it. We're having FTR issues. Yeah, that's why it restarted. Yeah, let's, yeah. Okay, we're gonna make sure. Okay, Ms. Ray, if you're able to hear us through FTR, please come out and let us know. Yeah, she's getting sound. Okay. Can you hear me, Alyssa? Nothing. I was gonna see if you could hear me through the. But she's getting. I know, but playback, but is it recording? And Megan, if,
It's picking up.
and she's picking it up through, yes. You're listening to the recording, right? Yeah, because when we access it, we can only access the recording. Here, yeah. Because it's, Megan can hear it on the recording. Yes. Yes, so we're, I know, so Megan will come bombing out here if it does. Yeah, okay. All right, just let her know if something happens to come out. Okay. Good? Ish? Okay, all right, sorry about that. Go ahead.
Yeah, so back to the question. So was the defendant deprived of his freedom of action in any significant way, or is placed in a situation in which he reasonably believes that his freedom of action or movement is restricted by such an interrogation?
Yes, you were detained, but not in custody.
Yes, I wasn't free to leave, right?
No.
Okay. So the defendant was deprived of his freedom of action.
Yes, you were detained.
Okay. So, are you aware of Oregon versus Madison? It says reasons believe, well, it says at the very least, if respondents obtained an objectively reasonable belief that he was not free to leave during the questioning, then he was deprived of his freedom of action in a significant way.
No, I'm not familiar with that.
Are you familiar with People versus Ronnie? The custody requirement of Miranda does not depend on the subject intent of the law enforcement officer interrogator, but upon whether the subject is physically deprived of his freedom of action in any significant way, or is placed in a situation in which he reasonably believes that his freedom of action or movement is restricted by such interrogation.
Judge, I'm going to object. I don't think this is relevant to the 3-5. This sounds like out-of-state authority.
Mr. Ochoa Ibarra?
Supreme Court case ruling. So,
Well, and I don't need you to debate the law with him. What I need you
and
to
I'm just asking
listen-
him a question if he's aware of that.
No, but again, if you can talk about, you can argue the law to me, pull the facts out that you need from him
Okay.
that support your legal conclusion.
Yeah. Okay. So, did you know that the defendant was on private property at the time when you interacted with them?
At the time that I made contact with you, yes, you were on private property.
Yeah. So, when the defendant told you that he was not going to give you ID, are you aware that that's a right under the Fourth Amendment?
No, can articulate that you came off of Highway 395, a state road. So the fact that you were on private property is irrelevant at that point.
Do you remember in talking with, I think, Swim, or if not with what's his name, with Lee, are you aware when you told him that, can you get the video because without that I have nothing?
Yeah, that's my proof. So I can tell the court and the jury that, yes, I saw you, but the video is my proof. So
Yeah, so,
that's,
so did you physically see me though?
yes, I physically saw your vehicle right off the highway, and I can articulate that the only way you could have got where I saw you was coming off the highway.
Um, oopsies. So, what does detain mean?
Detain is to keep you from leaving.
Or were you aware when Swim came up to you and he started asking you about dropping all the other charges and just charge him with forgery?
I'm gonna object. This assumes facts, not evidence.
Mr. Ochoa Ibarra.
I think it's relevant to, I'm asking him about what happened there.
No, but again, what relevance does that have to what the nature of the interaction was between you and him? A conversation that he had with another officer.
That was in the truck.
But what relevance does that have to do with your custody status?
Oh, okay, sorry about that. Was there a 911 call that, or any complaint from the gas station owners or the members of the public regarding defendant or his vehicle?
And I'm gonna object. It's not relevant to 3.5.
Mr. Ochoa Ibarra?
How is that not relevant?
Because how the call initiated is not relevant to the nature of your interaction with Detective Feldner if you were under arrest. So something that happened or didn't happen before has nothing to do if you were in custody.
Was being detained the same thing as being arrested?
No, detained is different than being in custody.
What's the difference?
Being detained is you're not free to leave, but you're not under arrest. Being in custody means you're under arrest and you're going to jail.
What caused you to initiate the interaction with the defendant?
What caused me to what?
To initiate the interaction with the defendant?
The initial interaction
Yes.
is the vehicle matches description of an excavator theft.
And you said that the vehicle was black?
A black truck pulling a car hauler.
Did you know that the truck was actually blue?
Looked black to me.
Um, so is being, oh, why can't you ask that either? Let's see. So can you cite any statute or case law that specifically allows you to detain or question uh, an individual on private property absent a warrant or complaint?
I'm going to object to the form of the question, and Detective Feldner is not here to give a legal opinion.
Mr. Ochoa Ibarra.
Well, I think it has to do with the whole interaction and him actually coming up to start asking questions and stuff.
Right, but we're not eliciting law from him. You're not debating the law with him. You can argue it to me. You're pulling out facts that support legal conclusions. And again, you can argue the law, but I'm not gonna have you ask him if he knows about specific case citations or ask him to generate legal authority for you.
Yeah, sorry about that. Are you aware of the Fourth Amendment? Am I able to ask that?
And until there's an objection, you can ask.
All right. Yeah, are you aware of the Fourth Amendment?
Yes, I am.
So according to the Fourth Amendment, does a defendant, is a defendant required to ID according to the Fourth
I'm
Amendment?
going to object. He's asking for a legal opinion again.
Again, we're getting back into you're debating the law with him.
Okay. Let me see how I can ask it.
Yeah, are you texting with somebody?
No, I got my question.
Okay, all right.
Yeah, sorry if I'm taking long.
No, you're fine, you're fine.
Did the defendant have a right to not identify?
No, not when he has committed a crime and the investigating officer is asking.
What crime did he commit? But when you first interacted with them,
Driving a vehicle with no registration.
did you know that at the
False
time?
plates. There was no plates on the trailer.
But you're saying that the vehicle, you said the vehicle though, not the
The
trailer.
vehicle had fictitious plates on it, but the trailer had no plates. That's why I contacted you.
Yeah, so having a plate on no plate on the trailer,
That's
that's
a
a crime.
violation.
Is that a crime or
Yes, it's what's
that it's a traffic infraction?
infraction, but I still legally can ask you.
I thought it was
for
only for a
identification.
crime.
No, infractions as well.
So what's the definition of a crime? Or am I able to ask that? Or no?
Not relevant to the 3-5.
Again, we're getting into debate over the law.
Okay. So would you say that that not having a plate on the trailer gave you probable cause?
I'm gonna object. We're not here for probable cause.
Or that it's about the interaction that, like how if he even had the right to interact with me?
That's not an issue in this hearing. The issue in this hearing is Miranda. That's it.
Okay, sorry about that. Christensen.
You're okay.
Yeah, don't look at me so seriously. You know, I love you, man.
This is how he looks at everybody. Go ahead.
I bring the witness some water.
Yeah, I'm sure.
So when the defendant said he didn't want to ID because there was no crime, what did he have the right to do that?
Judge, I'm gonna object again. He's asking that. What is legal question?
Again, so the question I have, and you are on the right track, is I have to determine if the circumstances in your interaction with Detective Feldner rose to the level of a custodial arrest. If you are under a custodial arrest, and that's got a specific definition, that triggers Miranda. If Miranda wasn't read at the point the custodial arrest happened, any statements after that are not admissible. So that's what I have to decide today is when were you placed under custodial arrest?
Yeah, okay. Depriving someone of their freedom of action in any significant way, is that considered custodial arrest?
I didn't understand you.
Oh, sorry. That depriving the defendant of any freedom of action in any significant way, is that a custodial arrest?
No, that's detained. That's being detained, not custodial arrest.
Did the defendant provide ID at any point?
Yes, well, not, you didn't physically provide it. You gave me your name.
Yeah, and did the defendant say that he was only going to give it to you only under duress?
That's what he said.
Did you threaten the defendant with arrest if he didn't ID?
Yes, I said you would go to jail if you didn't provide identification.
Is that considered a threat?
No, that's obstruction. It's a criminal citation, arrestable offense. So I was giving you an opportunity.
So that would be a threat wouldn't they? If you tell someone that if you don't give me this, then this is what's gonna happen. So that's under threat, right?
Don't object, asked and answered.
What?
Asked and answered. You've already asked him the question and he's already
Okay.
answered it. Was the
Okay.
objection.
All right, sorry. So let me think if I'm trying to think if this would be the right question to ask. 'Cause I know that I can't ask you anything about law, right? Yeah. So when you, I think I asked this before, but I'm gonna ask just in case I didn't. So you were saying that the um not having a plate on the trailer was an infraction, right? That's what you said. Right.
Can you say it out loud, please?
Oh, he's asking you.
Can you say it out loud?
Oh, yes.
Was the defendant out of his truck when you came and interacted with him?
Yes, I had watched you step out of your truck as I pulled around. And then when I stopped, you were out of your truck by the time I got to the back of the trailer.
I don't remember seeing you on the side, but yeah, because even on the video, well, yeah, I can't. I'm not sure if I can even say that. Could I say anything about that?
Well, no, because you're not testifying.
Oh yeah, okay. Um, did you initiate your lights at any time?
No,
Was this a consensual encounter?
I'm sorry.
Was this a consensual encounter? Like, did the defendant consent to you asking him about
Most of the time they don't, but
Mhm. So, so you didn't oversee a crime, at the time?
I'm sorry.
You didn't oversee a crime at that time
Not until I got behind the vehicle.
behind it?
Yeah.
But I thought that was an infraction, not a crime.
An infraction, I can still make a stop and still contact and ask for ID.
So when the defendant refused to ID, why did you continue to ask him and make threats?
I didn't make threats. I gave you options.
So you think saying that, or like giving me an option, see how I can ask this. So you think, yeah, let me see. So you think you will take someone to jail is an option absent a crime?
I'm sorry?
That you think giving someone an option, to go to jail absent a crime, is, I'll just ask it like this. So you think saying you will take someone to jail is an option absent a crime?
Yes, because I was giving you the option to either give me your ID and you don't go to jail, or if you obstruct and not give me your ID, then you go to jail. That's the option.
Well, is obstruction a secondary charge?
Is it relevant?
Don't debate him. If there's a relevancy objection.
Is it what now?
Is it a secondary charge?
Yes. There's multiple charges or infractions and criminal charges.
So if anyone's on private property, can anyone just come up to someone and demand ID absent a crime?
If they saw them on a public roadway first, yes.
Judge, can I move for the close of testimony? I think it's pretty obvious at this point that Mr. Ochoa Ibarra does not have any questions prepared for this hearing. He's just looking things up on his phone and trying to ask, and most of
Not
the
looking things up. I have questions on it.
I'm still talking. And most of the questions are completely irrelevant to the issue of whether or not there was a custodial interrogation, whether any statements were taken during that, which Detective Feldner already testified there weren't any. All of the statements were before Mr. Ochoa Ibarra was placed under arrest. So everything that he's asking is pretty much irrelevant at this point. He's consuming an inordinate amount of the court's time by his lack of preparation for this hearing.
You have any other questions about the interaction and whether or not it was custodial?
Yeah, well, I was just reading through some just to make sure that they were irrelevant. I mean, that they were relevant, and so I'm trying not to ask any questions that are irrelevant.
Okay. I'll give you a little bit of latitude.
Thank you. Is suspicion a crime?
I'm sorry,
Is suspicion a crime?
I didn't understand you.
Suspicion of being suspicious?
Okay, again, this is beyond what is the scope of this. This is again, pulling out facts about your interaction with Detective Feldner to determine if it was custodial or not.
Okay, sorry. When did the defendant reserve his rights to privacy?
What do you mean by reserve your right to privacy?
By him not giving up his ID because it was
Right at the beginning, when I
right at the
first
beginning.
contacted you.
I think that's all I got.
All right, Mr. Christensen, any redirects?
There are
All right, Mr. Christensen, any other witnesses?
no other witnesses.
All right, Detective Feldner, you can step down. Mr. Ochoa, Bart, do you have any witnesses that you'd like to call?
I call my wife.
That's fine. Come on up. She's fine. Can I have you raise your right hand, please? Do you swear or affirm that the testimony you'll provide the court in this matter will be the truth, the whole truth, and nothing but the truth?
I stand on the word of God, and the word of God says not to swore, and your yes be yes.
So do you swear or affirm that you're going to tell the truth?
I affirm, I don't swear.
Okay, that's fine. That's the other option. Okay, all right, have a seat. And if I could begin by having you state your full name for the record and spell your last, please.
My name is Jasmine Penaloza, and I am a living being, and it's JazminPenaloza.
All right, Mr. Ochoa Ibarra, when you're ready with any questions.
So when we got to the, I can ask it like that, right? I can ask it however.
If there's an objection, Mr. Christensen will make it.
All right, thank you. So when we got to the gas station, did you see any police cars or trucks around the property?
No, I was almost to the gas station because I was gonna go bathroom and then I saw the truck. Like pretty much pull around a couple times. Not a couple times, it's just, I saw it going slowly to the back, I mean, and then I was kind of looking back to see what's going
And
on.
then after you seen the truck slowly pull off to the side, did the truck continue to go around the parking lot before it actually stopped behind the trailer?
When I saw it, no, but on the video, you saw it.
Okay. When you went into the store, did you see Fellner in there?
No,
Let's see, did you witness Fellner coming up to me and talking to me?
no, when I got out of the gas station, he came up to me. That's all I didn't see him physically go to you.
So when we all got out of the truck, did you see any well, like, yeah, after we got out of the truck and you guys were heading to the store, did you see any cops or any trucks or anything?
Not till I was getting almost into the store.
Okay. Do you think that the defendant was deprived of his freedom of action in any significant way when Fellner came up to him and started talking to him?
Wait, hold on, what? Say that again, sorry.
That was I deprived of any of my freedom of action in any significant way when Fellner came and first started talking to me?
When he told you you were not free to leave?
He never told me that if I was free to leave. He pretty much I'm just asking you that when he first came up to me, did you?
There's no question pending.
If you can ask a question.
Okay. Let's see. Do you think that the defendant was deprived of being free to leave when the interaction started with Fellner and him?
Yeah, because he didn't allow you to leave. He didn't let you to leave. He just wanted you there to, I don't know, figure out what was going on. But he didn't allow you to leave, so you were being detained, which I believe is the same as being arrested, because you're not free to leave. If you're being arrested or you're not free to leave, you're detained.
Was the defendant in any way like hostile or like being rude or anything?
No,
Um,
you weren't cursing, you weren't yelling at them, weren't being rude.
I think that's all I got.
All right, Mr. Christensen, any cross?
No, Your Honor.
All right, thank you. You can step down. And then Mr. Ochoa Ibarra, any other witnesses that you'd like to call?
No.
All right, and then Mr. Christensen, any rebuttal?
No, Your Honor.
All right, so any brief argument, Mr. Christensen?
Submit on the memorandum, Your Honor.
All right, Mr. Ochoa Ibarra, any kind of argument here at this stage?
Argument in what way?
That you were under arrest during your interaction with Detective Feldner?
No.
No? So do you, oh, okay, never mind. All right, so this interaction started, the testimony was that Detective Feldner was at the Spoko Fuel. He saw Mr. Ochoa Ibarra pulling off of the highway and then ultimately contacted him. And he indicated that the reason that the first contact was made was the fact that he thought that the vehicle matched a description of a vehicle and trailer that was related to an excavator theft that he was working on. And I know that there was a fair amount of testimony about a detention versus an arrest. And while a common nomenclature would be that they're the same thing, they are in fact two different things. So when a person is speeding down the highway and they're pulled over for a traffic infraction, they are not free to leave during that point in time, but they're also not under arrest in that type of situation. So that is what's known as a detention. There's other in other circumstances where a defendant can be detained, and that is what's considered a Terry stop. And a detention is a brief interaction between a law enforcement officer and a citizen where the person is not free to leave, but they're also not subject to formal arrest. The question of how long brief is depends on the circumstances, the scope, and what's been going on here. There was also some discussion that when the threat of arrest was made, when Mr. Ochoa Ibarra was not providing any information, that he essentially was given a Hobson's choice in that situation where he could either continue to participate or be subjected to a formal arrest. But what's key here from the testimony, and I think what's been come out here, is that during this entire interaction, until handcuffs were placed on Mr. Ochoa Ibarra, there was no restrictions on his freedom of movement. In the police reports, and I think here we had people walking around, we had Mr. Ochoa Ibarra's wife present, we had them interacting with other individuals, and there was never a formal placing of handcuffs, and a defendant's subjective intent about what's going on in their own mind is not sufficient to warrant an objective person from the outside looking in that they're under arrest. So again, not detention, but under arrest. An arrest requires all the formality of arrest. That involves Miranda, that involves handcuffing. The other option is a total and complete police-dominated situation where you have lots of officers that are displaying weapons, that are directing where everybody can go. And again, the facts here indicate that people are able to move freely about. As far as the threat for arrest, there's a case called State versus Radka. This was in a situation where they actually told the person that he was not under arrest. They actually said he was under arrest, put him in the back of a patrol car, but didn't put him on handcuffs and allowed him access to a phone. So if you can put somebody in a patrol car and still have not restrained movements there, then I think we don't get there. So here, until the handcuffs were put on, this was a detention. This was not a formal arrest. Miranda was not triggered. When Miranda was triggered, it was appropriately read, and then it was invoked. So the statements at the gas station between law enforcement and Mr. Ochoa Ibarra are going to be admissible. Any other issues that we need to discuss from the state's end as far as motions this afternoon or this evening, Mr. Christensen?
I just have one scheduling issue, Your Honor. We have a witness that's not going to be available tomorrow. She's testifying in Spokane. This is the manager at the Spoko Fuel. She's the witness for the video. She will be available on Thursday at 9 o'clock, though.
Okay, and I think we've got, it looks like 3 or 4, looks like there's 4 law enforcement that are available that we should be able to work through tomorrow.
Yes.
Okay. And then Mr. Ochoa Ibarra, any other kind of housekeeping issues before we break for the evening?
Would I be able to do like an evidentiary hearing or get a, like an investigator or any of that stuff?
Between now and tomorrow? No. I mean, and I don't know what you mean by an evidentiary hearing either.
Just like getting evidence and stuff like that, like and subpoenaing and.
I mean, this has been pending since last year, so the time for all that, and again, you've known this is the trial date, the time has come and gone for all of that. You can, if you have, I suppose, witnesses that the state's aware of that you'd like to testify, you can certainly do that. I'm gonna order that all witnesses be excluded from trial, so if witnesses are gonna be testifying, then they're not gonna be able to be in the courtroom while other witnesses are testifying, and they're just gonna have to wait in the hall. So when you're thinking about your witnesses, that's what you need to take into consideration, that they can't, like, for example, like if you want your wife to testify, she's not gonna be able to sit through the trial. She's gonna have to wait in the hallway or somewhere else. But again, and if there's not, do you have any witnesses at this point in time that you're intending on calling? No?
No.
Okay. Okay, so then I guess procedurally, we have jury packets. Okay, those will be made available tomorrow morning. And then inevitably, we have juror issues, especially with the weather and everything else like that. So if everybody could be here about 8:45 in the small courtroom, basically we have people that their car breaks down or they're sick, and then we have to talk through a lot of that stuff on the record. Who's my clerk? Is it Hannah?
Like
Okay.
the officers are gonna be here. I'm gonna be able to question them as well, or
They're gonna all testify.
I'll be able to question them though, or
They're gonna be up here testifying tomorrow.
okay.
So tomorrow morning, what we're gonna do is we're gonna start with jury selection. So I don't know if you're familiar with that, but I'm gonna restrict both sides are gonna be restricted to 45 minutes with the whole panel. Given the nature of these charges, I think that's more than sufficient. So other than that, we'll get everything sorted out, and then once we know what's going on with the jury, we'll proceed from there. So, Mr. Christensen, anything final that we need to discuss right now?
No, Your Honor.
Mr. Ochoa Ibarra?
That Jeff Evers that was on the call, would he be here as well, or?
He's not been subpoenaed, so unless you've made other arrangements to have him here, I guess now Detective Evers won't be here.
Would I be able to subpoena him?
You'd have to get him served by tomorrow.
Okay.
Any other questions?
No.
Okay, so we'll see everybody tomorrow morning at about 8:45 in the small courtroom. All right, so we are adjourned.
All right.
I'm going to be honest with you, that was a little tough to watch. And the reason it was tough to watch is because Papa didn't follow the process. Papa filed a interlocutory appeal. Papa Bear didn't argue his points of authorities very well and go over those. He was just talking about honoring y'all's oath and the Constitution. He wasn't prepared for any kind of questioning in relation to Feldner at all. He didn't go down the right proper steps as far as if you're going to go that far, you got to do it the right way, and you got to prepare yourself the right way. You got to come in there with questions ready to roll. You got to come in ready. You got to be prepared. When you coming through when you coming through, when you coming through, let me throw this over here real quick. Okay. Let me throw this over here real quick. You arguing just the aspects of what now? Wait a second. Let's get this right. How do I go over to My screen, is that the right way? How do I do this? Let's do this right. How do we do this? Uh-oh. Uh-oh. I'm messing up some. Uh-oh. Uh-oh, I'm messing up some. I don't know what I just did. Oh, is this right? But where's my camera at? Oh, there I go. Okay. Are we in that thing? Where's the box at? How do I make it bigger? Oh, it's too big, Cam. Alright, we in this thing. Alright. I don't know how they just got on the aspect of only getting to one topic, which was the aspect, how do you only get to the one first off, how do you not call an evidentiary hearing? How do you not get to the aspect where you're already preparing the aspect of who you're going to subpoena? How are you already not? It would be something like this. When you approach the defendant, did you already have an intention to issue a citation? Stop for a moment. We on this one right here, okay? We're right here. Were you merely investigating something you personally found unusual? Let them answer, okay? Question. The gas station is a place of business open to public, correct? Are you aware that a person has an expectation of privacy when parked on a private property? Okay. Since the defendant was not observed operating the vehicle on the highway, I mean, you're stating that, but you don't have proof, right? Okay. Are you aware that Washington law generally does not require registration or licensing of vehicles that are stationary already on private property? Okay. Did you have any prior knowledge of defendant before this encounter? Okay. So, why did you single him out for investigation? Okay. So you noticed he had plates that were all the same on all three vehicles? Okay. So you wouldn't think that all three vehicles you don't think he would reasonably, okay, well let me ask you this. Do you think he thought that he could put one license plate on all three legally as though they were legally applicable in regards to, okay, you don't know. Okay. All right. So was there a 911 call or any complaint from the gas station owner or any member of the public regarding the defendant or his vehicle? Okay, you said black. Did you observe that the defendant's vehicle was blue? Okay. And did you question him about anything being stolen? Or was it specifically about the plates only? Okay. So then again, honestly, the stolen aspects in which you're claiming here today had nothing to do with you speaking with the defendant, correct? Okay. So is it your testimony that you initiated an interaction with the defendant entirely of your own accord without direction from the dispatcher or complainant? Okay. And is there a complainant other than yourself? Okay. And are you the complainant itself, like a verified complainant? Do you know? Okay. So Washington law requires that a crime must have an identifiable victim or harm. Are you aware of that? Oh, no, that's right. You said it was an infraction, correct? Okay, so a crime would not, this isn't a crime, correct? Right, you can still ask for ID, correct? And did the defendant reserve his right to remain silent? Okay, and then did you make a threat of arrest? Okay, and then he was under duress, right? Okay, so you made threats that you really couldn't because there was actually no crime, correct? And he was parked on private property already, correct? Okay. Just wanted to make that sure. So, let me see. So Washington law requires that a crime have an... Okay. If there was no damage or no injury or no one requesting police assistance, how do you justify taking legal action against defendant even after he reserved his rights to remain silent? Or not to identify? Just to remain private? Okay. And can you point to any statute that allows you to take action against an individual without a complaining party or direct evidence of harm? Oh, so you're using the fictitious plates or forgery? Okay. Now, were you originally going to write the tickets in relation to forgery? Okay. No. Okay. So you were just going to write tickets and let them go, correct? Okay. All right, good. So can you, let me see. If no one was harmed and no property was damaged, on what factual basis did you believe criminal charges were warranted? Right? Because there were criminal actions brought forth. Who initiated those? It was a sergeant. who had a phone call over to Jeff Evers, who then conspired together over the phone, saying that he should be arrested when he had done no crime. And then they went over to them, and he said over to Fellner, "Hey, Fellner, Evers says it's a forgery. You can just apply that." And literally, the dude, Swim, talks him into bumping it up to a felony forgery charge. If no one was harmed, okay, would you agree that as a law enforcement officer, your authority is limited to enforcing laws and that you are permitted to impose your personal beliefs or discretionary interpretation of what constitutes a crime? Okay. You cited the defendant for failure to transfer a title. Are you aware that this statute classifies the violation as a non-custodial misdemeanor and does not justify a warrant? Just not justify an arrest in and of itself? You see what I'm saying? There's a lot going on here. There's a lot going on here. Nature of the plate. Let's get into that one. Questioning of that. You claim defendant's plate was fictitious or forged. Did you personally examine to determine whether it mimicked a state-issued form? Can you specify how it appeared official? Did it bear a governmental seal, an official registration number, or any official Department of Licensing hallmark? Oh my God. Are you aware that RCWA forgery requires that the written instrument to be an official or recognized legal document used with intent to defraud? What evidence do you have the defendant intended to defraud or injure any party? Uh-oh. Did you confirm that this alleged plate was ever issued or authorized by the state of Washington, or was it purely a personal creation? You have likened the plate to a trip permit. Are you aware that valid trip permits are typically recognized by the Department of Licensing with official numbering? He said he looked it up in the system and it never came up. Thereby, it couldn't be a forgery or a counterfeit because he's not replicating something that is already official. Correct? Clearly! Did you ever see an actual trip permit or anything referencing an official state template in the defendant's possession? Okay. Now, I understand, Deputy Fellner, you say investigative, Fellner. Let's ask some investigative questions if you don't mind. This might be cool. Maybe you can answer them, maybe you can't. We'll see if the prosecution wants to allow these to kind of go through. It'd be interesting. So, are you aware that if there is any statutory ambiguity, I told you, it's getting deep. You're an investigator now. Statutory ambiguity, meaning that, like it's not being disclosed, I don't get fair due process, as to whether a personal plate is covered by forgery, it must resolve to the defendant's favor under the rule of lenity. Objection! I thought I'd at least get it on the record. All right. So did you consult a supervisor or legal advisor to confirm the existence of probable cause for felony forgery? Oh, that's a good one. Because who did he consult with? Yes, he advised with a supervisor. And they coerced and conspired to bump it up to a non-applicable statute. Now, at what point did you inform the defendant he was under arrest, and on what specific charge? You see, all these things, bro, evidentiary, you're supposed to have all of them come up in there. You're supposed to have been subpoenaed, Jeff Evers, and all that. We was all telling Papa Bear a long time ago to do this. I don't know what happened. People gonna do what they want to do, my guy. And all we can do is try and help as much as possible to be a resource, to be a collective people to try and help as much as possible. But, we can't make you do anything. Clearly, people gonna do what they want to, And in that, we're here to support them. And, man, Papa Bear's got a lot of work to do for tomorrow. So we're going to have to see how that goes. I got a lot of people that I was supposed to be on an appointment with. This went way longer than it was supposed to, so I got to get to them. I hope you learned something here today. I hope you know that we're at least here together as one. There's a lot Homeboy's got to learn from this type of situation. Of course, he's got an appeal that he can hit right off the bat. Just that aspect alone, but hopefully he's prepared for tomorrow. And he's definitely going to have to practice a lot. And this is a lot to take in for him. I know it is. But again, you got to be prepared, man. And Papa Bear didn't go in prepared, y'all. And that's why I help people get prepared. I do as much as possible to help people. And I'm here as a resource to people. And, you know, it's like Joe said earlier, man. Papa Bear's had a lot of help from us. A lot of help. And you can see he's worked on things. Motion for evidentiary. I don't know why he went and tried to file a interlocutory appeal. He knows what's up with that. Show 5 more projects that he's been working on. Right? 25 of them. Writs and all, bro. There's a lot here. PC questions. Louis response to DAs. He didn't hit none of the responses. Or any of the scripts. So, you know. Papa didn't come in prepared. He didn't come in prepared. And we don't give advice. We give education. We give developments. We give perspectives. I'm saying, hey, look at it from this angle, look at it from that angle, and then collectively just prepare, you know. And if you prepare properly and come in with the right questioning and knowing the process, again, it's all about following the process. You got to follow the process. And if you do the process right and you're able to articulate the process and the points of authorities in the way that I've been showing everybody to do so, yo, you become really powerful. But you start stepping outside of that, you can start getting hemmed up, and you don't hit with objections, and you not, you know, taking out certain rulings and then calling for disqualifications. When you see bias, it's reasonable, and you can prove that. I mean, man, you're getting hemmed up. I mean, homeboy, the judge just literally said, you know, do you got any witnesses to call upon? And he's like, nah, I ain't got none. It's like, yeah, you do got some, bro. Just by you responding when he says, do you got any witnesses? No. Like, come on, man. So this is a real good learning point for everybody that's involved with Operation Wise Dome, Power Inherent in the People. You have to prepare. Okay, this isn't just like, I'm going to hop out here and file some paperwork and hope that everything disappears, unless you're going with an injunction. If you hitting them with an injunction and filing on the circuits above, yeah, I can see where that might fit into play. For sure. If you're doing it by the process, but coming in not prepared when you got dude in a suit on pretrial and you ain't called nobody else to come in, you ain't called an evidentiary hearing, you've never even filed for a motion to suppress, you know all of these things, but yet you haven't done them. Yo, man, we got to be prepared and follow the process. This goes to show me, I mean, he knows I hit hard on this. I mean, I did a live stream almost 2 weeks ago, if not 10 days ago or longer, saying, hey, man, you got to follow the process. Calling this exact thing out. And nothing was done in that time. It was, I'm going to file a motion in relation to jurisdiction. I'm going to go in on my next hearing and file an affidavit not being attached to a motion. We gotta know the process, y'all. We gotta know the process. We gotta know how this works. If you don't know the process, you're gonna get bamboozled, just like what we see today. You're gonna get ran through, okay? Especially if you ain't taking it up on an injunction. So again, this goes to show we have to be more prepared. You have to take you have to take it serious when I be talking about the process, y'all. That's a real deal thing, okay? I don't know how to be. I mean, what do y'all tell me? Y'all tell me what you think. Let me see. Tell me what you think from now on. I'm looking at the chat. Fears from lack of preparation. God bless you and thank you for being here as a resource. Wired Wonderland. Truth is Sovereign says we assist. Farmer says it's all advice. People either accept it or not. Casey says be grateful to be here learning with everybody. Philosophy from Freedom says, I appreciate being given the opportunity to be part of this experience too. Lynn says, no victim, no case. So why is this even a continuing thing to think about? Because he didn't pay attention? He didn't listen? Doug says, get to your appointments, Cam. I think everybody will be understanding that what I do is I dedicate myself to every single one of you when you're needed. We have to back each other. We have to back each other. If we're not standing to back each other, then what are we doing this for? Appointments are cool and all, but I think all of those people will be more than understanding. Okay? I definitely think so. Casey says, I've learned so much today. Give thanks. For sure. It is. It's a big learning experience that you have to follow the process. And if you're not following it properly, we've given everybody in the Discord's got the basic procedural guideline as far as what goes through in the process. Then you got an educational brief to allow you to go into deep detail. This is a good comprehension and aspect of knowing that on Wednesday we're going through the process in relation to jurisdictionary. Again, the process is so important, y'all. Too much M's says we need more mock trials. Troy says you're a rock star. No, you're the rock star, my guy. Go on and wave that hair around and feel it as you do. Nervousness can scramble your brains in a bad way. Yeah, and you want to know what it is? It's not knowing that you are, first off, it's not being prepared. But it's also, I feel like there was a nervousness there. There was intimidation there. I'm coming through like I'm standing on it, bro. And if they ain't trying to hear it on the front end, I would have already hit for the disqualification. I would have hit for the disqualification a long time ago when he straight up said, well, in my mind, I see this as, I don't see this any difference between your license plate and a trip permit. I do, bro. One's paper and one's privately made. I don't see how you cannot see any different of that. Like, you out here wilding trying to, man, there's all kinds of bias going on. Yeah, Thomas, they did. They threw a bunch at him. My boy couldn't, he was hitting him. He said, oh. My boy was getting hit. He was getting hit. What's the solution when the judge and the prosecutor are lawless? Mike says. We all know, but are too chicken. It's injunctions, bro. And you hit them with a disqualification. If they are already reasonably showing any bias in relation to anything that you can prove in relation to what you've brought forth, like me, homeboy didn't even bring forth any arguments in relation to the rule of lenity or the whole rule act. Like, how you not going to correlate those two to give a solid point of understanding that there was no due process or notice given in relation to the private plate? Because all there is the aspect of a written instrument being a trip permit. Like, none of that was articulated and argued. It's a non-moving violation. They over here being like, oh, well, we pulled up to you while you was on private property and we observed you pulling off. Okay, you may have observed me pulling off, but the moment in which I reserved all my rights and didn't speak to you, which is what I would have done, I reserved all my rights. I'm not talking. Once I reserve all my rights and you arrest me anyways, you start doing all this hooping and hollering. Like, I got arrested in Hood River. Like, bro, what? What's going on? They arrested me right off the back and raided my Miranda rights. So, yeah, man. I know I got a 5 o'clock coming up. This has been a long one. Again, I hope y'all really did enjoy what was going on. I hope you learned a lot. This is a resource to understand. You've got to be prepared. If you're not prepared to go in there and do it the right way, by following the process all the way through, you just go in there on one day and say, I'm filing my affidavit. That's not how this goes. You can't do it like that, y'all. You got to really go in there hitting them hard. We got to follow the process. I'm here to support you, Louis. We love you, brother. And you're going to get through this trial. I believe you're going to be really prepared tonight. I bet you're going to be prepared with questioning for every single officer tomorrow. I bet you stayed up all night. Boy, you better, if you don't drink coffee, I bet you drink some tonight. All right, till the next one.